Hi. Hi. Wait. Hi, friends. That's not even the right name. I hope you're all well. I hope you can hear me. I hope you're having a wonderful Saturday. I just had, oh, well, hi. Anybody new? There's like three spots left. Hi, Mindy. Welcome. We're pretty cool. Oh, we're pretty cool. I am in a different kitchen than I normally am right now. Also, if you have subbed and I'm less than 1,000 subs, you're in the 1K club. Welcome. Hi Donna. Thank you for being here. I had a bad idea just a moment ago. I thought, it's not like you're starting a live in a moment. Why don't you absolutely try and change how you normally do things? So, and I'm going to show you because I do the behind the scenes thing. So, I tried to attach the camera thing to that light, which is probably a bad idea. And it's precarious. So I'm going to take that down slowly and carefully before it falls on you guys. Good to know. Okay. So what we're going to do today, I hope most of us really like being here to watch court together. And so if you've seen something before, that might happen here. That's just the way it is. But what that means is we get to have fun together. So in the evening, did I really? That's so exciting. I'm going to check in a second. I want to get court going so I'm not like playing you guys long and I'm going to put some lipstick on. Anyways, what we're going to do today is we're going to watch a TPO hearing that was one of my first ever videos that I posted. Some of you may have seen it, but I want to hear your opinions on it. And yeah, I'm excited. If you're new here, you can be in the 2K club apparently, because apparently the 1K club is full. Ah, that's exciting. So exciting. Oh my gosh. I'm glad to everybody here for the first time. This is not normally my kitchen, but I flit and float to different kitchens. So anyways, what we're going to do now, check this out. I will move out of the way. Normally I set myself in the Zoom calls, so you have to find me a little bit. But this call, yeah, I can fit. I'll just come over here. But what this is a doctor, and so the two bottom people here, the woman is the petitioner, and the man is the respondent. And we have Judge Foxworth up here. And this is going to be a TPO hearing. And so the lawyer right here beside the judge is for the respondent, the man. And the lawyer at the top right is Miss Shockley, is the lawyer for the plaintiff, the female. The plaintiff is a doctor and the respondent is a police officer. And so there's some really interesting dynamics that go on here. And as usual, we try and be respectful, but we're funny in the chat, folks. So if you have a question, ask a question, but we joke around a lot. We have a great time. You're going to need a sense of humor. I'm I'm a lot, but I just hit 1K. I'm pretty happy, and I couldn't have done it without all of you. I love watching court. I've been doing it for years. So let's keep going. Also, when you see me do this, that's a red flag, folks. That's something that, anyways, I do that so that I don't unmute myself all the time, but that's just the way it is. And also, you'll see me doing things. I got to clean up and do a bunch of different things, but I'm here listening, watching, and for everybody new here, I appreciate you. There's a point system that happens where you get points for every couple minutes that you watch, plus randomly we give out lots of different points. And a lot of the friends here have been here for a long time. If you have a question about court stuff, this is a great place to ask it. We're probably not lawyers, maybe some of us are, but we can point you in directions and we've got lots of experience. So please enjoy what we have coming up. And yeah, thank you all for being part of my absolute amazing community. And if Time Serve sent you over here or looking at legal stuff or Credence and Mikey, then you know I love all of them. If you're not already subbed to them, that's a must do. Okay? I love you all and let's get going.
Process, calling her personal and work phones incessantly, texting endlessly.
So that's basically the sum total of where we are at this point. So I wish that y'all had been able to resolve it. I thought we perhaps had a band-aid approach that might work for 2 to 4 weeks that would have achieved many of the things that y'all, your attorneys had been working towards, and both have done a fine job of thinking outside the box. So we may have gotten a little too far outside our box for this court and what its power and authority may be. But there were ways to make it happen, and so you have turned it over to me, and I will be handling these issues and see where we go. All right, Ms. Shockley, you're representing the petitioner. Do you wish to give an opening statement very briefly?
Yes, Your Honor. Thank you. So yes, I'm Rachel Shockley. We've just met this morning. It's nice to meet you. And I represent Dr. Courtney Stewart. I previously represented her in her divorce from Mr. Hawkins, who is the respondent in this matter. The divorce was finalized at the end of November 29th of 22. So they have not been divorced long. Mr. Hawkins did not want the divorce, and during the period of the divorce proceedings, he harassed and abused Miss Stewart throughout the entire process, calling her personal and work phones incessantly, texting endlessly, showing up at her house when she was paying for him to live somewhere else. I spent a significant amount of time speaking to his counsel. He went through 3 different counsel. I spent a significant amount of time begging them to try to get him to stop communicating with her when it was, and to refrain from the harassment and stalking behavior. And unfortunately, it did not end during the divorce process, and it has continued after the divorce process, and it has indeed escalated rather than de-escalated, which is unfortunate and not what we had hoped. The parties are the parents of one minor child, Harrison Stewart Hawkins. He is 1. For that reason, they will always have a connection. Okay, and so that is, we can't just say we're not going to pay attention to each other. They will always have a connection. By agreement, Miss Stewart has sole legal and physical custody of the child, and Mr. Hawkins has certain visitation. Miss Stewart wants Mr. Hawkins to have a relationship with his son, but unfortunately, Mr. Hawkins weaponizes the child, including refusing to give his location, refusing to return him in a timely fashion. But more basically, he just uses the child as a way to contact, as a means of being in contact with my client constantly. And while he attempts to pretend that the communications are about Harrison, they always devolve into harassment and abuse. And just the sheer number of communications is harassing, abusive, and rises to the level of stalking. And then the content takes it to a whole nother level. The evidence will show, to the point of the incessantness, the evidence will show that even post-divorce, he will call Miss Stewart on her personal and work phones repeatedly on almost a daily basis, just one call after the next. There's no reason for these calls. He texts her incessantly, texting her over and over when she does not engage or when she asks him to stop. There are pages and pages of messages from him, and he won't stop, even though she's not responding. Even when there's nothing of substance to discuss, it's just spewing anger. The parties also use OFW, and he sends unnecessary and threatening messages through the app, in addition to the text messages and the phone calls. We will provide the court with examples of these text messages and OFW emails, and the court will see that Mr. Hawkins degrades Ms. Stewart. He uses profanity constantly. He makes such statements as, "Your medical," meaning your medical insurance, "is canceled," to which Ms. Stewart responded, "Okay, thank you. I'll get coverage for us ASAP," to which he responded, "You sure fucking will." He repeats it. He repeatedly makes veiled threats by saying such things as, "You're only making this more difficult on yourself. It's all fun and games until you realize the game is over. You have no idea what I can do. I hate you. You can fuck off." He calls her names: dumbass, fool, fucking asshole. You're a horrible person. He repeatedly tells her to shut up. And this is all in writing. So there's really no way that he can deny that. My client will also testify regarding things that he has said to her that are of similar nature, threatening, that he's gonna, she doesn't know what he's gonna do, threatening to contact the medical board and cause her to lose her medical license. And then most horrifically, and what really sort of, we finally just had to say uncle, was he threatened to kill her and this January. And she will testify as to how that occurred. So that goes to something very important for the court to understand. That is that Mr. Hawkins is in law enforcement. He was a police officer. He is now currently with emergency management at GSU. He knows, because of his position in law enforcement for many, many years, he knows how to walk a very thin line as to, and he thinks that he can outsmart the system. And he tells Miss Stewart that he can outsmart the system. For example, after Miss Stewart filed for divorce, he pushed her while she was holding their infant and said, "I've been a police officer for over 20 years. I know better than to leave a mark." And so it's those kinds of things. He often becomes violent. He damaged property at the house when they were married, kicking walls, slamming doors until they cracked. While all of that is scary enough, Ms. Stewart's fear of Mr. Hawkins is intensified exponentially by the fact that he has an arsenal of weapons. We have some photos of certain of these firearms, but he has even more than those that are pictured in our exhibits. As part of the divorce, he was supposed to give her an inventory of the firearms, including the serial number, etc., and he's supposed to have them in a safe for the child's protection. He has not provided the inventory, and despite being served with the TPO requiring him to relinquish his firearms to law enforcement, he has not done so. He simply does not follow the rules. He does not believe that they apply to him. And so to date, as far as I know, he has not turned over the firearms to the police, even though we appeared last week on this matter. And he has not secured, as far as we know, he has no way of securing the guns in his apartment where the child visits. He is known to leave weapons out where a toddler could access them. For example, we have a picture of a handgun in a compartment in a couch right next to the remote control. So these are legitimate concerns, and that's why they were addressed within the context of the divorce. One might wonder why Ms. Stewart didn't offer protection from Mr. Hawkins a long time ago. And she will testify that she is afraid of him, that she always just tries to keep the peace, so that things don't get too bad, that there isn't just like she would rather him just be calm. And she will testify that here today she's very concerned, and that she stays up at night wondering if this gets entered, what happens, and if it doesn't get entered, what happens, because there's going to be fallout and she's scared of him. All that said, she wants him to have a relationship with his son, despite his constant accusations that she wants to ruin that relationship. She has done nothing but support it, even in the face of all of this abuse. And largely that's because Miss Stewart is a rule follower. And he is the father. She wants him to be involved. He has visitation schedules. She's going to follow the rules. Unfortunately, he hasn't followed any of the rules. He hasn't followed the temporary order. He didn't follow the divorce decree. He hasn't followed the divorce decree. and now he isn't following the TPO. And he just believes he's above the law, and so he's got to. There's got to be some repercussions. There hasn't been any, there hasn't been any like consequences that matter to Mr. Hawkins, and he throws that very much in Miss Stewart's face. And for example, the perfect example of this is after having been served with the TPO, he continued to contact her by phone and text. We notified him. My office notified him in addition to him being served, in addition to us notifying his employer so that we could receive the handguns or the firearms that are associated with his work. And he just decided that, nope, sorry, I don't believe that this is a legitimate, or I don't think this is valid. And so he just continued to do whatever he wanted. And so, he acknowledged in his correspondence that there was a TPO, but he was, quote, deciding that it wasn't valid. And so he was just going to continue his behavior as he so desired. As though all of this wasn't enough, upon information and belief, Mr. Hawkins has been hacking into Miss Stewart's emails and her internet system. Early in the divorce, he was ordered to sign over the internet account to Miss Stewart when he left the house. Per usual, he refused to do it, even though it was a court order. He didn't do it. She finally got a second account because she was worried that he was accessing her system. He has a background in IT. And then, interestingly enough, it wasn't until the TPO issued, but he finally canceled that first account as soon as the ex parte was in place. And so my suspicion is that he has been reading her communications for a year or more. The evidence of family violence is clear. Mr. Hawkins must be prohibited from continuing to harass and abuse and stalk Ms. Stewart. He needs help. He needs classes in domestic violence. His conduct is interfering with Ms. Stewart's ability to parent, her ability to work, her ability to get the child medical treatment. He refused to bring the child to an appointment one day and refused to say where he was. This is just destroying her life. She's constantly worried about what he is going to do next. Is he going to throw another fit at the daycare and they get kicked out of daycare because that happened? That could potentially happen considering former behavior that she will discuss. Is he going to throw a fit at the bank to the point where the bank employees asked Miss Stewart if they would like, if she would like for them to call the police? Is he going to refuse to return the child? Is he going to refuse to pick up the child? Is he going to refuse to bring the child to the doctor's appointments? It just goes on and on. And he is stalking and terrorizing Miss Stewart, and we are asking this court to enter the 12-month protective order and all of the relief that Your Honor set forth previously. And that would also very much include the surrender of all of his firearms. And it is our understanding, and my client will testify to, I do believe that if he was a police officer still, that obviously not being able to have a firearm would impact his employment. But from what he explained to my client when he received the new job at GSU in charge of emergency management, firearms are not required. He requested that he be allowed to maintain his badge and his firearms, and they granted that, but it is not, in her understanding, a requirement of the job. And I have seen nothing that states that it is. And so I'm assuming that it is not required, and that was something that he asked for, and he was given that privilege. We are asking that visitation be modified during this period, that no overnight visitation occur, that it be supervised for a period of time. And certainly we would suggest perhaps that be the period of time be when he was attending the family violence program, and that once that was complete, that then we could maybe move away from supervised visits and back to something more normal. The child is 17 months old. he's a 17-month-old. He gets into stuff. You have to have a lot of patience with him. This is, this is an age where you need patience, and that's something that Mr. Hawkins doesn't have, and that could result in a disaster. And indeed, he constantly returns the child early from visitation because he doesn't have the patience to parent him for any extended periods of time. And so, that's something that we're asking for in addition. I think it's important to know, Your Honor, that Mr. Stewart rented a 1-bedroom apartment, despite the fact that he has a toddler and probably should have gotten him a place with his own room. But the apartment it's just right over a mile from Miss Stewart's residence, and he can be at her house in just minutes if he gets enraged. She would not have time to get the child in a car seat and leave the residence if he decided that he wanted to come there and hurt them. And indeed, when he rented the apartment, he told her it was, quote, within striking distance. And so that has also been something that has weighed very, very heavily on her, and particularly as things have escalated to the threat of killing her. Ms. Stewart and Harrison need to be protected. I believe when the court hears from Ms. Stewart and reviews the additional evidence, the decision to grant the 12-month protective order will be clear. Thank you, Your Honor.
All right, Ms. Robinson, do you wish to give your opening?
Yes, Your Honor. Good morning. My name is.
Good morning. Sorry to interrupt you, Miss Robinson. My name is Kitchen Court Cases, and we are breaking in with breaking news, ladies and gentlemen. We have just officially reached 1,000 subscribers on the Kitchen Court Cases channel. I know it's been happening for a while, but I wasn't about to interrupt Miss Shockley. I'm trying to learn my stuff and not interrupt people. Woohoo! But yeah, we did it. You guys are all here. It feels like you might be late to the party if you just subbed, but believe me, we are just getting started and we are going places, my friends. So I am happy to have you. We are having a good time. I will be dancing. I'm literally in a bit of shock right now, to be just frank with you. A goal that I set for myself that I never ever tried to work on until a month ago has now come true. So I am ecstatic. I am thankful for each and every one of you. The reason I watch court is because of the interaction and engagement that we have together. The comments that I get sometimes are so thought-provoking, even the negative ones, that I really don't mind. I'm not the type of person that gets turned off by negative comments. So even, it's all engagement. But seriously, I couldn't have picked a literally more serious situation to have on at the same time. But you know what? That's the way it is. I am thankful for all of you. Seriously, I believe it. I am very thankful. A little speechless, which doesn't happen a lot. But I do hope this is the first of many, many, many subscriber goals. And the reality is that the people here, we make friends, and they may not be in real life right away, but one day can happen. And I just love you all, seriously. So let's continue on. What we just had there was the introduction from attorney Rachel Shockley. She's representing the petitioner down here right above me, right there. And this woman is a doctor, and this guy is a cop. And this is a serious situation. And some of you may have seen this before, but like I said, I honestly digest these cases a lot better when I'm with the chat, because sometimes I think things and then I say it in the chat and then someone tells me, no, think about it like this. And I'm like, oh, okay, yeah, fair enough. Like that is, to me, the key to how we do these things. So, Plus, we have a good little critical eye that we look at towards the lawyering, the judging, the zooming, all the fun stuff. And this case stuck out to me because it is extremely serious. Some of the cases, like, some of you may not have been here before. Is it a little high? Did that make it higher or lower? I should talk at the same volume. Anyways, here's the thing. This case is serious. I'm hoping that you can hear it. This was one of the first cases I ever recorded. So yeah, the quality is not as good as it can be. Cooking, absolutely. I got to figure out what to make as well. Also, in real life, guys, I am loud. That's just the way it is. I have a good mic. It's like one thing I have. So I have to remember that part. Let's get back to watching this. Let's hear the respondent. So the father's official opening statement, and then see where we go. Oh, what I was going to say was, if some of you have come here from the Thomas, I would love to see some cheesecake. Just in the chat, there's a Thomas. I'm speaking to you. I am specifically speaking to you about cheesecake. It's important, and I want to see it. Anyways, if you came from the divorce case, which we've been doing earlier, this is sort of another divorce case, but in total opposition to that case, these people are not annoying. This situation is scary and serious, but it's not contrived. That divorce case I just felt was so, contrived. Yeah, this is DeKalb County, Georgia. DeKalb County, Georgia, folks. Also, yeah, leave in the chat what you're having for dinner tonight and what you want to have for dinner if you're not having what you want. I got corn pops back there. How do I know? How do I know? I know everything. Anyways, okay, let's keep going. I love you all.
Jenny Robinson, as we had met earlier, and I have been retained to represent the respondent, Mr. Harry Adam Hawkins, in this matter. And we are here today before this court to assert that there's absolutely no grounds for this protective order, as the petitioner, Ms. Stewart, nor the party's minor child, Harrison, are nor ever were at any time before or during the party's marriage in at risk of any imminent harm, danger, or injury attributed by Mr. Hawkins' actions. As we are prepared to support with evidence, including our family wizard course correspondences between the party, as Ms. Shockley had stated, that these issues involved in this matter are not that he poses a risk to their safety, but that they're in fact proper for contempt. These parties were recently divorced at the end of November, and there were certain things in the parenting plan, the final divorce decree, as well as the settlement agreement, in which both parties were instructed to comply with. And as you will see today, that all of these things that Ms. Stewart has taken issue with, as she has falsely stated that they are proper grounds for a TPO, actually proper for a contempt matter. And therefore, we would request that this court dismiss this protective order so that these issues can be properly resolved in the proper court. Now, Ms. Shockley just came before you to try to paint this picture of Mr. Hawkins as some type of villain, as someone who has done nothing but harm and harass the petitioner and break all the rules for the entirety of their relationship. However, what she failed to mention is that Ms. Stewart is not as much of a rule follower as she claims. She too has not followed some of the parenting plan, some of the settlement agreement as the parties have proceeded past.
Okay, we're getting some freezing
and
up.
other documents of the
Ms. Robinson, hold on a second. I'm not catching everything. Ms. Robinson, excuse me for interrupting.
I just remembered that this happens and there's a bunch of technical issues, but so far we have a doctor mom and a cop dad divorced in late November with a 17-month-old child, and the mom wants a TPO. So I can't remember if there's a point in this video where they had to disconnect, I believe, and do something else because the respondent's lawyer's internet was so bad. But let's watch on. If it's super bad, I will try and skip forward. Oh, kitchen is getting cleaner.
And can you hear me? Okay, you're on mute now. Okay, your screen was freezing, which also distorted your vocal as well. Your audio was off.
I don't know, I think she's frozen.
Frozen again.
Can you hear me now?
Yes, you're breaking up a little bit, but try again.
Okay, how about now?
Much better. Okay. I'll ask you to repeat the last 2 or 3 sentences at least.
Okay, there's a delay because when I speak versus when you hear me is different.
Okay. Well, it was distorting it. So go ahead. Let's see how we go.
Okay. Ms. Shockley just came before you and tried to paint Mr. Hawkins as some type of villain, some type of rule breaker. However, what she failed to mention is that Ms. Stewart herself is not as much of a rule follower as she claims. She too has not followed the parenting plan. She too has not allowed Mr. Hawkins to have the visitation as he is ordered to in the court. There has been times in which she hasn't responded and but she has made things difficult in order for them to co-parent. She is the one who actually imposed.
Okay, you're frozen again.
Let me text her. I don't know why it would either not be always wrong or
Well, we were having the issue in the hearing I had previous to this one, but one of the parties was in Oconee County. I understood there were some storm issues in his area, so I'm not sure what's going on, but maybe she can log on again and let's see what happens.
The second I speak,
you might be to try to call her, Your Honor.
Well, her client can text her or call her if possible, sir.
Your Honor, yes. I've got her on the line now. She's having internet difficulty. She's trying to log out and log back in at this time. So
Maybe we'll get a better connection then. Thank you.
I just got a text from her She says, my paralegal says our internet is down.
Uh, I was so over the Zoom world after COVID, and I was so happy to get back in the courthouse, and then all the pipes bust, flooding many of the courtrooms.
Could have service on my phone anyways, but I'm trying to get this resolved. I'm sorry, the whole internet, I'm literally using someone's hotspot right now, but the whole internet. So I do extremely apologize for this inconvenience.
All right, you may proceed while you can.
I know, I'm gonna try to get it out really fast, man. But yes, however, during the party's marriage, Miss Stewart was actually the one to physically impose harm against Mr. Stewart. However, even after filing this TPO, Miss Stewart continued to engage in regular communications and interactions with Mr. Hawkins. You will hear today from Mr. Hawkins through testimony, as well as proof by our family wizard messages, how even after Miss Stewart filed this temporary protective orders, she continued to talk about the minor child. She continued to even instruct Mr. Hawkins about the proper care for the child after he had his ear procedure. And in fact, she agreed to meet with Mr. Hawkins and did at a public park. Now, when she met, there was no police presence. The police were never called. There was no one else to supervise this exchange. It was just Mr. Stewart, their child, and Mr. Hawkins. Nothing happened. They were at no point of time at risk of their safety. And if they are, Miss Stewart took absolutely no means to protect themselves as she claimed she needed to. And they had a peaceful exchange and went about their business. And that is because at no point of time during the party's marriage, nor at any single time during the divorce proceeding, was domestic violence an issue, an allegation, or mentioned by Ms. Stewart. The parties engaged in mediation, in which they were required to fill out the domestic violence survey, in which neither Mr. Hawkins nor Ms. Stewart stated that Mr. Hawkins had ever committed any type of violent act against her during their relationship. And that's because he was, nor is, a risk to Ms. Stewart's safety, and especially not the party's child. This action is improper and a farce upon the court and a waste of this court's time and resources, as all these matters should be properly handled and addressed in a contempt action related to this divorce. Now, these accusations against my client and the imposition of this protective order would not only substantially impair upon my client's ability to continue to foster the loving and intimate bond that he has with his only son, but it will also have severe consequences as offenses against his character and his reputation as someone who was in law enforcement for years and someone who still acts in a law enforcement capacity. Mr. Hawkins is currently employed in an emergency management situation in a law enforcement capacity with a local university here in Georgia. He's in charge of being in charge of all the security monitors and managing all of the security protocols for the university. As a former law enforcement officer and one who is in charge of thousands of students' safety and who understands the risk of firearms and working with vulnerable populations and what severe implications would come through from threatening to kill someone's life. Now, Mr. Hawkins has never made such a threat against Ms. Stewart. Having this action against him, having this protective order granted against my client would go against the very oath he took and promise he took to protect the people. It would have a substantial impact on Mr. Hawkins' current career and any future career opportunities as a law enforcement officer, as it would substantially impose upon his ability to care for his son, as well as provide for his son with a life that both parties agree that he deserves. that there is no evidence of harm as the petitioner is erroneously claiming. Mr. Hawkins at no point of time threatened to kill her, and you will see that there is no evidence, apart from Ms. Stewart's own words, that he ever threatened to kill her. Now, we have a multitude of messages as well between Mr. Hawkins and Ms. Stewart from the time in which the petitioner claims these behaviors begun to show the interactions between the parties and to further prove that Ms. Stewart's claims are erroneous, false, and misleading. Now, in regards to Ms. Stewart's claims in regards to the firearms, Mr. Hawkins, as I stated, is a former and is currently a law enforcement capacity, and he owns a firearm, one that is issued by his employer. Now, however, as a result of his career change and the birth and the age of the minor child, he no longer has use for these guns to be in his home. And as you will hear from Mr. Hawkins himself, all of the firearms in which the petitioner will claim that he has are no longer in his possession, and that they are in fact secure in a protected place outside of his home and are at no risk to the party's minor son. He will not he is willing to offer the petitioner Now, however, as a result of his career change and the birth and age of the minor child, he no longer has use for these guns to be in his home. And as you will hear from Mr. Hawkins himself, all of the firearms in which the petitioner will claim that he has are no longer in his possession, and that they are in fact secure in a protected place outside of his home and are at no risk to the party's minor son. He will not he is willing to offer the petitioner with the serial number for the firearm that he currently had in his possession, as well as the one that he turned over to his job after this action has been filed. Therefore, at the end of today's hearing, after you will hear the evidence how Mr. Hawkins is not a threat to Ms. Stewart's safety, how he has never harmed her, has never inflicted violence against her nor their child, we would respectfully request that this court deny this petition for a protective order and not grant the 12-month protective order, as this matter is not proper and should be properly conducted in Superior Court under contempt or modification action. We will prove that Mr. Hawkins has done nothing to put Ms. Stewart in imminent fear of her or the minor child's safety, and instead should go away with this matter so that the parties can proceed with their lives and continue to hopefully effectively co-parent in the future. We would request that this court deny the petitioner's request for any type of cost, any type of family violence treatment that would be imposed, and that we would also request that this court deny the petitioner's request that Mr. Hawkins' visitations with his minor child be restricted, be supervised, or any different than was agreed upon in the parties' final judgment and decree of divorce, as well as the joint consented parenting plan. And we would just emphasize that Mr. Hawkins by no means should have a protective order issued against him at the end of today's hearing. Thank you, Your Honor.
Thank you both. Before we actually begin, let me explain, as I had explained to both counsel, there are a number of issues perhaps that will arise today over which I will have zero jurisdiction and may be better served for both parties and the child in handling. There are going to be issues that y'all are both going to need to handle anyway in Superior Court on the divorce action. So our jurisdiction is fairly limited in what I can and cannot do. I have to be mindful of the order that does exist, but there will be issues that I can't necessarily modify here, but we'll address those as we come to them. So with that said, Ms. Shockley, you may go ahead and call your first witness.
I call Dr. Courtney Stewart. Should I swear?
I'll let you swear in.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Please unmute.
I do.
Okay.
Could you please state your name for the record?
Courtney Eileen Stewart.
And were you previously married to Mr. Harry Adam Hawkins?
Yes.
And do you have a child with Mr. Hawkins?
Yes.
What is your child's name?
Harrison Stewart Hawkins.
And how old is your child?
He'll be 17 months the end of this month.
And what is the custodial arrangement which the two of you reached by settlement?
I have sole legal and physical custody.
And does Mr. Hawkins have visitation?
Yes.
What is that current schedule?
He currently has the first and the third weekends from Friday at 4 till Sunday at 6, and then the Thursday night preceding my weekends from Thursday at 4 p.m. to as late as 9 a.m. on Friday.
All right. Can you describe the frequency? Let's not talk about the content yet, but just the frequency of communication you received from Mr. Hawkins and the types of communication?
Yeah, so he typically through text messages, texts dozens of times a day. Also call as well. I tend to block him when it's not his parenting time with Harrison to avoid these calls. But then he just calls my work number when he knows I'm at work to talk to me. And we'll call, back to back to back until I answer. And then if that doesn't work, then he'll send an Our Family Wizard message. So it's just pretty nonstop communication. I think the most times he's ever called me is 30 times in one day. That day, there were probably also at least 25 to 30 text messages.
Your Honor, as a technical matter, the exhibits that we forwarded to the court, how do you like to handle that? Do you like to do screen share or?
If you will let our staff know what exhibit you wish to present, they will pull it up and we can all see it from there.
Okay. All right. Let's go ahead and jump to the text messages. If we could please see Exhibit L, Petitioner's Exhibit L. Ms. Stewart, can you identify this document for us?
But we haven't got it pulled up yet.
Oh, wait, yeah.
Right in front of her, I didn't know you did.
I think you mean Exhibit M, the text messages.
Is it M or L?
M says text on the directory.
It is actually L, I believe. It's
L says email.
M.
oh. You could open. Let me see M. Maybe I missed.
Okay.
Yeah, it's M.
I apologize. Misnumbered my own exhibits. Okay.
Ladies and gentlemen, one of the things I do on this channel is dramatic readings of text messages. When I pull myself, probably stop touching the microphone. I never do that. And then now I've got 1,000 subs and I'm like, I'm a star. I need to touch the mic. Okay. We are reading the text messages from him to her. I'm not using that app. If you ever want to swap days, it will only be approved via email. It's a two-way street moving forward. It's the entire amount of $220 that you are trying to drag out another 6 months. I'm not working with you until everything is completed. This is how you wanted it, and now you got it. Please don't test me. It will just make things more difficult for all of us. Her response: yeah, I'm not made of money, and I spent $40K on you since February, so I don't have $220 on me right now. Okay, well, that seems a little, just now, this is my thought. That seems a little unbelievable. If you had 40K, 220 is nothing. But, anyways, let's continue.
All right, Ms. Stewart, could you please identify this document for the court?
Yeah, this is a PDF of messages between Adam and myself from December through, I guess, beginning of February.
And obviously, we don't have time to go through every piece of this correspondence, but I would like to tender this as plaintiff's M and ask Ms. Stewart some questions about it if there's no objection.
Any objection, Ms. Robinson?
No objection, Your Honor.
All right, may proceed. It's admitted without objection.
All right. Let's start with if you look at the bottom of the first page, where it says the first payment is due 1/1. Can you tell me a little? Can you give me the context of that statement? That's coming from you, correct?
Yeah, the blue is from me.
We do have time to read them. So, after she said, yeah, I'm not made of money, and I spent $40K on you since February, so I don't have $220 on me. He goes, yeah, you're rich. I'm poor, remember? You thought you could threaten me the way you did on the 6th IVF attempt, insult me, keep child from me, and accuse me of threatening you.
This is part of our settlement agreement. I have to pay Adam $220,000. And so the first installment was $200,000, and it was due on January 1st, 2023.
And so you were responding to his.
Sorry, did y'all hear that? Her first payment to him is $220,000. Listen on.
Statements prior to that, which basically in which he demands that you start making the payments now, correct? Tells you to take out a loan.
Yeah, he wanted the entire amount, the $220,000 he wanted it all at once, and he didn't want to work with me until he got his money. And this is from the beginning of December. You know, I think the divorce had been finalized for maybe like 5 days at this point.
And so the payment was not due at that time.
No.
All right. Can we turn to the second page, and if you could just read the court that page.
Sorry, gotta read this. And yes, looking at legal stuff is here. Thank you so much. Yet again, I am so thrilled I've made 1,000 subs. I am so proud and thankful. But let's continue reading on. So what's happened in this case, this is one of the first cases I ever posted on YouTube. We're watching it live. But basically, this is a doctor who's the mom and a cop who's the dad. The dad is the one who's in gray for the text messages. The mom is in blue. The mom has agreed to pay him $220,000 in order for him to sign his rights away. And now she's going after a TPO. So I'm about to read some of the text messages here. And let's see here. He says, you've only paid for problems. What a waste of money. Please get child. This is stupid. Thanks. Also, I'm just inserting child for their child's name as much as I can, just for some decency. I don't want to talk anymore. Do you enjoy this? Because I'm fucking over it. She responds, I just picked him up. He replies, it's only gonna get worse.
In the text message, I don't know exactly what we call it, the log.
From what part of it? From where I talked to him, or?
Just from the start of you've only paid for problems, just
Oh, yeah. So he texts, you've only paid for problems. What a waste of money. Please get Harrison. This is stupid. Thanks. I don't want to talk anymore. Do you enjoy this? Because I'm fucking over it. And I just wrote, I just picked him up.
Excuse
He continues, you have no idea how bad this is. Your medical is canceled, asshole. She replies, okay, thank you. I'll get coverage for us ASAP. He replies, you sure fucking will.
me here. Ms. Shockley, as I said a few moments ago, I have no interest and no jurisdiction over whether or not these payments. I'm here about one issue and one issue only. So
Correct.
if you have something in this very lengthy exhibit that is an example of alleged violence or threats of violence or that sort of thing, please proceed to that.
I'm sorry, I was just
Y'all can fight all day in the divorce action as far as contempt.
right, and I apologize, that was not the point. I was just trying to give some context, and the payment is not at issue. I think you'll see that the next sort of statements start to get into the threatening.
Then please, well, you said approximately an hour and a half, and so we need to get
okay.
moving.
All right, okay. So, Ms. Stewart, could you continue to read from that page, please?
Yeah, it's all right. I just picked him up, and then you said this is only going to get worse. You have no idea how bad this is. Your medical is canceled, asshole. All right, okay, thank you. I'll get coverage first ASAP. You sure fucking will. You should have gotten this when you canceled my car insurance since you want to play that way. I'll never forgive any of this. You're only making things more difficult for yourself.
All right, can you flip to the next page? Do you see where you asked for, let's see. So do you see the statement, I told you you're only going to make it more difficult on yourself?
Yes.
When you see statements such as that over and over again, and they're throughout this document, how do you interpret those statements?
I interpreted that Adam is threatening me that if I do not do things his way and the way he wants to do them, then there's going to be consequences and repercussions for me. You know, this is why we're divorced, so I don't have to do what he wants me to do. I can have my own thoughts and opinions and do my own things.
And for example, in his next statement, it's all fun and games with your stupid baby voice till you realize the game is over. What does that imply to you?
I mean, it means that he has something planned and there's some sort of retaliation coming if he doesn't get what he wants.
Okay, hold on, please. All right, Ms. Robinson, your objection?
Speculation as to the meaning of Mr. Hawkins behind the statement. Ms. Stewart is not in the mind of Mr. Hawkins. He cannot testify as to the motive or reasoning behind these statements, only to what they say themselves.
All right, Ms. Shockley.
She can testify as to how she interprets them.
I'm going to give a little bit of leeway here.
All right, and so
When there are alternatives to, as far as recourse for either party to file new actions in court, you have the burden of proof that acts of violence or threats of violence have been made. If a line can be interpreted multiple ways, it may not help your case. You may want to spend more time on those that can actually help your case than going through all of this line by line.
thank you, Your Honor. Okay. With that in mind, let's take some testimony and we'll potentially come back to Exhibit M.
All right, thank you.
Absolutely. All right. So, Ms. Hawkins, can you give us some background as to why you ultimately did decide to file for a TPO? Can you give us the back pattern leading up to you filing?
Yes, the divorce was a contentious and hellacious 11 months. And I truly thought that when we went to mediation, we reached a divorce settlement, and the divorce was finalized, that the behavior would improve and things would settle down. And now we had a plan and everyone knew what we were supposed to do and things would not be an issue anymore. However, instead of that happening, Adam became more and more upset about the agreement and his visitation and his time, claiming that his counsel was ineffective and that he was coerced into this settlement, and that, this wasn't fair and that I was going to pay for things. And so he would, show up at my front door unannounced, demanding time with the baby. He would, threaten me. We would do nightly FaceTime calls so he could see our son, even though he doesn't talk back yet. And during those phone calls, he would use that time to interact with our son as much as you can on FaceTime, but then also, tell me I was going to regret this, I was going to pay for this, things weren't going to be my way anymore. And then it got to the point where the beginning of January, we were on a call, we did a FaceTime call, and then during that call, he made threats to me about harming me. And, he said, if you don't allow me more time with my son, I will kill you. And, I believe him. I believe he's capable of doing those things. And then I guess it was like a week or 2 weeks later, there was a terrible weather day and daycare closed early. And I was able to get our son from daycare. It was before Adam's time started at 4 p.m. Adam was enraged that I had gotten our son from the daycare instead of him, demanded I bring the child back to daycare, which was closed, demanded I wake the baby up from his nap so Adam could start his time with him. And he was making threats to me. If I did not comply, there would be consequences and things would happen to me. As I know, Adam always has a gun on him. I very much thought that he could shoot me, he could hurt me, he could threaten me, and so I complied with him. And, his behavior then continued. A couple days later, I guess it was the next week, when he had his Thursday overnight and he was supposed to bring Harrison back so I could take him to the doctor's appointment, and he chose not to, and he was, on the phone when I did reach him, he was very threatening, and then he discontinued answering and stopped communicating, and I just realized that he
about where your son was at that time?
Yeah, I did not know where my son was. I called the police and they said it was a civil matter and they couldn't make him bring my son back. And I didn't know where he was going to be. All I knew was he, had lied about where they were. And, and he just told me, if you don't let me do this, then, you're going to regret it. You're going to pay for this. It's always, I'm going to pay for this. And he has, I just was done. It's been a long time of dealing with these threats and these actions, and I thought it was going to get better, and it just hasn't. And so that's when, I decided that I needed to take some actions to make sure that he realized that he couldn't continue to act this way, that there would be consequences, and that I, needed to feel like I could be safe in my own home or just anywhere.
So in discussing being safe in your own home, did Mr. Hawkins ever damage any property in the house when he lived with you?
Yes, he kicked a hole.
Excuse me 1 second. Ms. Shockley, let me also add one thing. I'm not going to consider anything that is not referenced in the petition. Is this in the petition or not? If something has happened since the filing of a petition, yes, I will consider that evidence. But I'm not going to go back. We're not going to dredge up things that are not in the petition. The respondent is not on notice, has no due process, giving him the advantage of what he's being alleged to have done.
I understand, Your Honor.
We need to restrict it. If you need to go back and look at your petition, that is all I can hear.
All right,
If
thank
you
you.
need to amend your petition, then we'd have to continue the case, but it's too late now.
I understand, Your Honor. That was pre-divorce, so I understand. Miss Stewart,
I mean, I'm confused, Your Honor, because the evidence portion said any past acts of violence or damage or proof of violence should be submitted as evidence. It didn't say that on the initial ex parte petition.
If it was not referenced in the petition is served upon the respondent, telling the respondent what the allegations are, the specific allegations.
I'm looking, hang on, Your Honor. I believe.
No, Your Honor, no.
I did not mention it because I thought it was only dealing with the exact threat at the time and that I'd be able to show his history of stalking and violence when we got to court.
Sometimes people will respond with the actual accusations that something happened 6 months ago or whatever. We can't go beyond the petition.
Okay. We understand, Your Honor. Thank you. So, in talking about Mr.
You can shake your head all you want, but I'm bound to hear only the evidence as to what has been alleged.
Could you describe Mr. Hawkins' behavior in the hospital the day that you all did ultimately arrive? Where he give us the background again? He did not show up for the appointed time, and how did he behave when he ultimately did show up with the child?
Just really feel like I'm being discounted right now. So this is really hard. Yeah, after I called the police and they contacted him and they said they couldn't make him do anything, bring him back, and he showed up an hour and a half later at the second medical appointment, and I had asked that he not be allowed to attend the appointment given our interactions, and I wanted security to make him leave, and he, played the victim and said, she's doing this, she gave me permission to be here, even though that's not the case. I had and rescinded it after his threatening behavior the day before. And, and he told me, you're going to pay for this. Like when I got the baby back and walked away, and he said, you're going to regret this. You're going to pay for this. This isn't the end of this.
And can you tell the court a little bit about some of Mr. Hawkins' behavior at the daycare center that has caused you concern?
Yes, when we were operating under the temporary agreement, he was not allowed to pick the child up for daycare. So I would pick him up from daycare and then we would meet him later. He went to the daycare and demanded, to see like sign-in logs, sign-out logs, demanded all this information that he is not entitled to. And I got there and he was screaming at me to fuck off in front of a bunch of infants and toddlers. And, telling me again, you don't control this, you'll pay for these behaviors. I'm his dad. It was, I had to have a conversation with daycare afterwards to make sure we weren't kicked out of the daycare from his behavior. And they said, they ban him from the property if he behaved like that again.
Can you describe an interaction that you had at the bank when you all were there? You can give the court the background of why you were there and then his behavior and what occurred.
Yeah, we went to the bank he refused to give me the information to make the wire transfer for the settlement money so I could be in compliance with the order.
Okay, Ms. Robinson,
I would object to relevance at this time. These particular circumstances, as well as the previous circumstances elicited from Ms. Stewart, were not issued nor alleged in the complaint, and they have no bearing on today's hearing in regards to the family violence matter that this court is here to hear. And since pursuant to your previous statements, since this was not properly alleged in the complaint, that we would just request that this testimony be stricken from the record.
Ms. Shockley, your response.
I believe it goes to a pattern of behavior. I believe that it falls under stalking, harassing behavior that is alleged. It's not every incident wasn't written out. No, but she has alleged the harassment. She has alleged the abuse, and these are examples of those things. And he is aware of his behavior, and I think he is on notice of the fact that these would be issues that would be brought before the court in a TPO hearing.
Perhaps if that is your aim in terms of eliciting this testimony, that there needs to be some clarification as to when these incidents occurred.
Certainly, Your Honor.
It could have been 6 months before I realized it was divorce related, and I don't want to get into the merits of who did what in terms of compliance with the divorce itself.
Correct, and that's
I
not.
understand if it's the spark that caused the fire, then I want to hear more about the fire than the spark, if you will.
Certainly, Your Honor, and this was post-divorce in recent times.
Okay.
So in the back.
I'll overrule the objection at this point,
Okay, so.
but I am instructing Ms. Shockley to get to the heart of the matter as far as how it ties into the actual allegations from the petition.
Certainly. So you were in a public place in a bank, is that correct, Ms. Stewart?
Yes, on December 31st, 2022.
And why were you there? Meeting him?
Because he refused to provide me the information so I could do the wire transfer of the $200,000. And so therefore he demanded we meet at the bank.
Rather you wanted to see you in person.
Yes.
Okay. And can you tell me how he behaved in the bank?
Yeah, he was in my face. He grabbed papers out of my hand and ripped them up. He was very much aggressive posture and threatening to the point where the bank asked if we needed to call security or they needed to call the police.
And how did that scene end?
He stormed out. And then after some period of time, I don't recall the exact amount of time, he calmed down and he said he wanted his money. So he and I wanted to be in compliance with the settlement agreement. So I agreed to go back to the bank and meet him again to make sure I could get him paid.
Thank you. Does Mr. Hawkins own personal firearms in addition to those that he has issued through his employment?
Yes.
Do you have any idea how many firearms he owns?
At least 24 by the last count I had when they were in the house.
Okay.
And some are assault rifles, actually multiple are assault rifles.
And after he was served with the TPO, as we sit here today, it is our understanding that he has not complied with the ex parte TPO and submitted those or relinquished those firearms to law enforcement, correct?
Not that I'm aware of.
And does that cause you concern?
Yes, because he can be at my house in 3 minutes.
And do you have concern that he generally just simply doesn't obey rules?
Yes, he didn't follow the court's temporary order from February of 2022. He didn't follow the divorce agreement from November 22, and he hasn't followed the TPO. And he's had zero consequences to not following any of these orders.
Let me ask you, they mentioned, or Ms. Robinson mentioned in opening that you were, quote, in contact with him after filing the TPO. Can you explain that to the court, please?
So I filed the DPO on January 16th. I had the hearing on January 19th. So in between that time, I continued to communicate with him because it wasn't granted. And then I was informed that I had to continue to, the visitation and everything else had to stay in place until he was formally served, which didn't happen until the 26th. So I had to just continue to act like I hadn't filed this, so that until I had legal right to act any other way.
And so once it was served upon him, did you communicate with him after that?
The day it was served, I was asked by your paralegal to find out his office numbers in case we needed those as well. So I did once I knew he was not at his office because it was after 5 o'clock. So I knew he was there. So I did call the office numbers from old emails to verify if that was his actual office number because I honestly wasn't sure.
But that was the only, what could have appeared to be attempt to communicate that you made post him being served with the TPO.
I did take screenshots of the calls from after he was served with TPO, and doing that, I did press the button to call him and immediately canceled it. So it was a less than a 1 second thing. There was no communication. It was just trying to take images of his calls after the TPO.
And he did, to your point, in fact, try to call you numerous times after being served with the TPO, correct?
Yes, and FaceTime and sent our family wizard messages.
Did he also text?
Sorry about that, y'all. I was watching this in double speed until I caught up. So now I have to fix the speed so they don't sound ill. Look, my kitchen is clean. Okay.
You.
Yes.
And when you did not respond, what was his excuse for ignoring the TPO?
I believe it's in the text messages.
I'm trying to get through this with as quickly as possible with testimony and exhibits.
Okay. So February 2nd, he texted, I requested to see H on FaceTime. It's been 11 days and there's not a valid TPO. And that was, several days after I guess a week after he had been served.
Thank you. Can you explain to the court how his behavior is impacting you on a daily basis and how it just in all areas of your life, how his behavior impacts you?
Yeah, once he left the house last March, I felt a little better, but then he would show up at the house whenever he wanted to, demanding to be, let in under the guise of seeing our son. the internet issue that has caused me, he's known about my communications with my attorneys. He's known about things that otherwise he wouldn't know about unless he was cyber stalking me. So that's led me to now only send emails through a VPN. I disconnected my doorbell because I don't want to know if he's at my front door. I keep the blinds of the house closed. If I have people over, I make sure they park in the garage so he doesn't know people are at the house. I'm afraid to take our son to the grocery store and run into Adam because we literally live 1.2 miles apart. And I just don't want there to be a public scene. And it, so I don't go to the grocery store. I've just had to change my life and how I live so that I don't interact with Adam, don't possibly do things that would cause him getting angry and upset and making a public scene, and causing us to lose our pediatrician or lose our daycare, or I've had people who don't want to help me with our son because they don't want to interact with Adam. They're scared of him.
And
so it's been very isolating.
Are you scared of him?
Yes. I asked him to go to counseling a long time ago, and he's refused, and he's continued to get worse. I never would have thought we would be here.
I also wanted to address something that was raised in an opening, and that was that he has alleged that you have been violent to him. Now, obviously, that is not in any petition or whatnot, so it probably doesn't need to be addressed. But, Your Honor, is that something that you would like to hear about?
Well, I would suspect it's going to come up on cross-examination since it was in Respondent's Counsel's opening statement. But if you wish to address it, that door has been opened.
I think so. Okay, so could you please tell exactly what occurred, what we are assuming he's alleging occurred, since she did raise that in the opening, that there was an incident where the police were called on you for alleged domestic violence. Can you tell us about that situation?
Yeah, that was last February 2022. When we had our temporary court hearing, and he and his family were instructed to only use the basement apartment in the house and enter through the exterior door to no longer access the garage. And he, as his nature, decided that that order didn't apply to him and he could continue to be in any part of the house he wanted to be, including the garage, and his family, his sister felt the same way. So we got into an issue where I was trying to keep him out of the house and he was trying to come in. My mother was on the side where I was, his sister was on the side he was. Anyways, it resulted in him claiming that.
So just to explain something that we probably all know about TPOs, but that maybe we just forget. So when a temporary protective order is first issued, it's issued on an ex parte basis, which means that it's done with one party and the judge without the other party there. That TPO, those hearings tend to be done they are not usually the ones that we are broadcast and seeing. They're the ones that give the first TPO that the person is served with to then come to court and follow up with this hearing. So an ex parte TPO is very likely to be issued more than not, because it's just one of those better safe than sorry sort of situations. So, however, what is happening is the average person might be able to claim they are not aware of the TPO process, the implications of breaking a TPO, etc. However, this gentleman is a high-ranking police official. And so I think it's out of the realm of probable that he doesn't understand a TPO or what it means when you're served with one, even ex parte. And so the judge, as we'll hear coming up, and I may, past me, might talk about this again, but it's concerning the way that he reacts to it, because he's not exemplifying what we would want a police officer to do. I know that domestic violence rates are high in lots of different industries, and being law enforcement being one of them. I also know it's a very stressful job. However, I think that it's just he's like playing with fire here, thinking that all these people who like this screen right now is full of people that know what they're doing. There's nobody dumb on the screen, including me. But do you know what I mean? Like, seriously, these people all know what you're doing. We got doctors, lawyers, judges, a cop, high level cop. So, anyways, also, if any of you are new, we've just hit 1,000 subscribers, and I'm so excited. It's been so exciting. I love watching court with you guys. I've been doing it for years. Finally started posting from my kitchen because that's where I am all the time. We're going to continue watching this. We're going to finish it today. But I want you guys to keep that in mind. Like, the reality about every person that we see in front of us is that they all come with their own sort of baggage and abilities or inabilities. And I'm all about saying, like, there are times when I think, well, somebody may not have known about that TPO being what it was. This is not one of those cases. And I think you'll start noticing the judge up here, he ain't happy at all about the situation. And I wasn't either. I was watching this like not happy at all. Anyways, also 200 grand, a lot of money. He probably, what I think happened is he signed over his rights to the child. He didn't sign away his entire like responsibilities or parental rights. He just signed over sole managing conservatorship. So they negotiated in a negotiated settlement. And he already signed it over. She followed through on the deal, and now he's become very weird. And so, to be honest with you, I'm on her side for this one at this point. And she may be super controlling 100%, but just like with the last lady in the divorce, don't sign it then. Yeah, he already signed it. And it bothers me when people go back on that. You have ample time to speak with a lawyer, to take your time ahead of time. Don't, you make your bed, lie in it. And it is frustrating, I can imagine, to her to realize, to have to come to terms with having to pay somebody that you used to love. And remember, I just read those texts. They went through 6 IVF cycles. Okay? That must be excruciating and difficult, expensive, devastating. They have 1 child. So you think that we have to give them grace as well. The likelihood of all the parents that live through infant loss, pregnancy loss, or even a disability of a child, the divorce rate is exceedingly high because those are high stress situations all the time. And so I'm not saying that she's perfect, not even close. I imagine, like, honestly, just looking at her and I probably wouldn't get along at a party. Like, she would probably be telling people things and I might be like making faces or something. Not that I wouldn't like her. I'm just saying we fly different paths. Now, but at this point, she's got the more solid pair of shoes on, in my sense. So, let's continue on. I'm going to do some tidying back here. I'm mostly doing celebrating because of 1,000 subscribers. And people mentioned, like, get me to 100,000 and get a silver play button. Oh, you guys, we're going to manifest that. That'll be my goal. God. I love you all so much. Seriously. She's a Karen. I'm a NERAC. For anybody new here, NERAC is a reverse Karen. I use all my Karen powers and abilities for goods only. So that is something you can do in your daily life. I promise you. Remember, all of you are valuable too. That's important. Let's keep going.
That I had scratched him, which I did not do, and I allege his sister did. And then they called Brookhaven police, and Adam became irate when the officer refused to have me arrested. He demanded a sergeant come. The sergeant came and said, "We don't believe that this is, that you did this," but he is irate and he is demanding that you be taken to jail. He said, "We're not going to do that." And so then they ordered, and then Adam ended up being upstairs alone in the house with my mother, and he threw a chair at her, and the police ran upstairs, ordered him to leave the house for the night. However, he returned an hour later. And the police at that time recommended that I might want to file for a TPO, but I didn't want to pursue it at that time.
Thank you for that explanation. All right, and you heard in the opening that he's willing to do certain things, such as give you an inventory of his weapons and things like that. Were those not already requirements under the divorce decree?
Yes, that was a requirement in the divorce decree that he's failed to meet.
And he's also failed to put the guns in a safe. He never retrieved the gun safe from your house?
Correct. He never had it moved to the apartment.
We have no proof that he doesn't have the guns at his house other than his word. Is that correct?
That's correct. He alleged that he moved them to his parents' house, but then the next week he told me he hadn't seen his parents in months. So I feel like he was just lying about where the guns are.
And when you all were together, did he always secure the guns or not?
No. There was always an unsecured gun. He always had at least one gun on him, and then he always kept an unsecured gun in the couch in the basement.
Is that a location where a toddler could access that gun?
Yeah, it has a little compartment that flips open, and it's in one of the exhibit pictures, but it's easily accessible. Harrison loves a hidden compartment.
Again, trying to stick with just testimony so we don't have to go through.
Well, you can go through, I'm not telling you how to try the case if you're
I do want us to get through this today, and I believe we're
going to get through it today. I can assure you.
Okay.
It may be, I may have to postpone if we get this other case in here, which is due at 1:00. I may postpone you until afterwards, but we're going to get through it today, however long it takes.
Okay. All right. Wonderful.
But I would appreciate efficiency, though.
I understand. Okay. If you could return to, I just want to do a couple of examples here. If you could return to Exhibit M, Ms. Stewart.
Okay.
Okay, let's wait and let staff pull it up, please. And if you can identify what page we need to go to, that would be appreciated.
Yes, page 15. Okay, could you start with?
Are we on page 15?
I'm not sure, Your Honor. That appears to be it. Yes.
Okay.
Yes, Judge, page 15.
Okay, thank you.
Could you start at the very bottom where it says, "I dare you to try anything," and could you read for the court the next several pages or the next page?
Yeah, so he writes, "I dare you to try anything. You have no idea what I can do." On the next page, page, he says, "Bring it on, asshole. It's on now. F off." You want me to keep reading? Oh, okay. So it says, and I say, "Adam, it's written in the agreement. If you cancel your time less than 48 hours notice, you're responsible for any childcare costs I incur." He wrote, "Don't care, don't care. You did this. You deal with every problem. There are going to be tons. What you've done's horrible, and I don't care. If it's going to suck for me, it's going to suck for you too." And I said, "You're choosing not to spend time with Harrison. That is on you." He said, "So what? What about what you've done? That's on you."
All right. You can stop there.
Okay.
All right, let's jump. And again, how do those comments make you feel?
Yeah, and I mean, this is again just when when things aren't going the way he wants them to, then he gets angry and it's just threatening and bring it on. And this is not over. This is not a game. It's just, to me, how I interpret that is that he's planning something. If I don't do things how he wants to do them, there's going to be retaliation.
Thank you. Okay. All right. If you could turn to page 30.
Okay.
Ms. Shockley, if you will direct her attention to something specific so we can move on.
Yes, certainly. Okay, so I'm sorry, if she could turn to page 30.
Yeah, she did.
Oh, okay, sorry.
Thankfully, and I've just now figured it out that it's got the page that she can access by skipping all the other pages. So we're there.
Perfect.
Okay, great.
That was faster than I thought too. Okay. All right. So if you could start with let's see. Actually just at the top. And where it says, "Then just tell me when I can get the safe."
He said, "Just tell me when I can get the safe. I thought you would have learned games are over. Some people just never learn." And so I wrote back, "The safe is legally mine because you failed to get it. You can buy it for me." "Bad move." He writes, "Bye. You have failed at every attempt. I don't want that safe. It would have been 400. Just move it. I'll just get a better one for my home."
Excuse me for interrupting. So the safe is actually your property?
No, he was supposed to obtain it when he moved out. He never did. And he had a deadline to get it by, and he didn't get it by that deadline.
Okay.
And so then just, I would like to note, as you flip through the next several pages, who is corresponding and who is not responding.
Or you just want to scroll through the next 3 or 4 pages or what?
Yes, if you just if this is the type.
Are there any specific text that you want me to see?
I'm really just looking more at the volume.
Okay.
X. Similarly, if you will scroll to page 43, and once again.
All right, we're there.
Once again, if you could just continue to scroll down to show the excessive amounts of text messages.
What are the dates? So these are scrolling pretty fast here.
These are this January.
Okay.
All of these text messages were post-divorce.
Okay.
Oh my gosh. Oh my gosh. I'm not going to read 43 pages, but shit, yeah, I'm going to read some of these. Absolutely. Dramatic reading. Also, for anybody who's having a hard time with this, please know you don't ever have to stay. I love you all. But if this is triggering for you, please duck out. Absolutely duck. The hard part is she is having to deal with him because of the child? iPhone 95? What is that? Anyways, let's continue. I'm going to go ahead. I'm going to read these as we go forth and see how we do. And you will, let's see here. He says, I mean the UPS store. I have my money. I have the deed. She writes, you can drop off a notarized and witnessed copy of the deed in my mailbox. He responds, you can fuck off. She writes, no money without the deed. I made that clear months ago. And he says, if I already gave it and you refuse to take the child. She says, you ripped it up on camera in the bank. He says, I did when you threatened me.
Page 43. And once again,
You've done nothing to deserve that I'm trying to work with you. By the way, the $20K you're going to pay B are for my legal fees every time I have to use an attorney till this is joint. I know exactly what I'm dealing with and how to defeat you. This book could literally turn into a movie. You just have no idea what happens outside of your limited view on things and the poor advice you get from the bubble you live in. There has been a serious misunderstanding on Full Legal. If you don't keep the app updated on every medical appointment so that I can go to every doctor visit, then it's just another example of not carrying, I think he meant caring, about the best interest of our child. Switch the custody around and give me what you have. Let's see how you like it. I've give you everything opportunity to stop. There is nothing worse than working against me with our child. You don't matter anymore. You've only made it more difficult for all of us.
All right, we're there.
once again, if you could just continue to scroll down to show the excess.
I have fun with the child. Enjoy another weekend being mean, he continues. Put in the app to my response to show how this was pulling teeth because you have issues. I'm taking care of our son the best I can, and all you can do is try to cause problems. Why do you accomplish by doing all this to the person that loves and wants the best for our child? And this was your idea. Now we have a child, and you just want me gone and keep child. What? You really should think about adopting a child that doesn't have a father so that you can do whatever you want. That's not going to him with my son happen. Everything I say is because of what you do and how you treat me.
Of tech.
You used a lawyer to begin this path of destruction rather than being a reasonable person and working together. And over time, I just chop away at getting everything back that you've taken by being a good dad and taking care of our son. Enjoy your important weekend. Not one response to any pics I sent of our son either.
Text messages.
I gave him cough. He's got the cough medicine. You know he's happy. Eggs, milk, French toast. He's got the cough again. I gave him cough medicine. Do you have any other suggestions to help him feel better? Let me know.
Well, what are the dates? So these are scrolling pretty fast here.
These are this January.
Okay.
All of these text messages.
Took the Band-Aid off, Adam continues. Of course, from the shot, I assume. Took the Band-Aid off. Of course, from the shot. There you go again, missing the point. He responds to nobody. You divorced me. I have to find a new home to raise my son. Put up with you complaining about money. You used your money to threaten me and kick me out if I don't do stuff your way. You made $1 million while we were married. I made $100K. You're paying $220K. None of that is for more time or control. That's your problem. You think you can buy everything. Show me in the agreement a breakdown where any money is for more legal or physical custody. Wow. Now that's a you new lie. You are just going down a dead end road. You can't buy a swap. You wanted a divorce and
Were post-divorce.
be unfair and mean your money can't fix shit. Well, we had the writer in the other divorce case, which was like, oh, I can't read this. This guy's got a better cadence, I have to say.
Okay.
This is all one day. These couple pages.
Well, I'm looking at it in terms of.
I'll continue. You are the problem. You can't play nice for 2 minutes, then get something and go back to being mean either. All those times you pushed me to do things your way, to do this, to now act like you have been since the child was born. I have more time with my son because of a judge, you asshole. I have more time with my son because the judge set the precedent. I don't need anything from you. I'll deal with one day at a time. This is the life you want. I want more time with my son. Until then, don't ask for shit.
The time frame relative to.
Let everything separate. You got it. No more FaceTime. We'll start with that. See you at tomorrow 6. For text reference, this and the following messages are in response to the FaceTime call we just had. Do not text me any dates or times or locations. Use the app. It shows what you read and doesn't respond to, and how long it takes for me to get medical info from you. Yeah, this dude is like, wow. Talk about level 10 clinger. Seriously.
To the filing of the petition.
From now on, I want to go to every doctor's appointment, and I'll let you know if I make one. Why, daycare told me you didn't sign him in yesterday. I could care less, but it was noticed. That's not something you forget. It's a routine that you have to do every day.
Correct, and it was right before she filed.
Okay.
Holy fuck. This is out of control. This guy's gone fucking nuts. I'm going to read this last page. I can't even continue. This guy is so desperate for communication with this woman. This alone would get a TPO from Judge Manning. This alone. Right here. He's trying every single possible way to get her to talk to him. He's got the child. He's like, you need to care. There's dry scalp. Oh my God. Jesus. I feel bad for her. I don't doubt she's controlling, but this is out of control, guys. This is out of control. Can you imagine giving somebody $200,000 and then they fucking come to you with this bullshit? Oh my God, I would be livid. I'd be like, go take a vacation, sir. Seriously, go to Mexico, find a fucking whore, and have a good time.
Okay, I think we're getting now towards the end there. Thank you very much. Okay. All right. I think that's all I have right now, Your Honor. I'll reserve, redirect.
Okay, do you have any other exhibits that you wish for us to see?
Yes.
I think that there's been, all right, actually, yes. If we could, turn to Exhibit E. I know, I'm sorry, I'm trying to,
And I appreciate you trying to make it efficient, but I just wanted to ask the question in case there was anything else in your presentation with this witness.
certainly, I understand, Your Honor. Exhibit E, HAH firearms.
Okay, are you gonna ask any questions relative to this?
Sorry, I'm so sorry. I've lost my Zoom screen.
We can see you.
I know, probably can, and I can't see you. Where are you? Now we're back. Okay. All right. Okay. Ms. Stewart, could you please identify Exhibit E for us? And you can, if the court reporter could scroll down so that we can see both pages, please.
Yeah. So the first,
Yeah, let her do it one at a time, please.
okay.
Can you identify this picture? Ms.
Yes.
Stewart?
Yes.
Okay. And
Yeah. This is a picture of Adam's handgun
okay, and
in this.
does he still own that sofa, to your knowledge?
Yeah, that sofa's in his apartment.
Your Honor, my lawyer, it dropped offline just to.
Oh, I'm sorry, I didn't see it because everything was over to the right.
Yeah,
Let's hold on, let her rejoin. Thank you for calling that to our attention.
Well, we're just waiting for her to sign back on. Interesting case so far, don't you think? I think that the judge is done with the Zoom. He's so finished with the Zoom completely. Anyways, it gets really good here because the husband actually testifies, and oh, here we go again.
Oh gosh, and she was texting me and I didn't see it. She was saying, I haven't heard anything.
Welcome back.
I'm sorry. Can everyone hear me?
Yeah, we're gonna go back to where we were in case you
I'm
missed.
literally on the hotspot, so I think it must be the weather because the hotspot is. I'm so sorry about this inconvenience. It's just not working for me at all today.
Did you leave us during this exhibit?
And you probably can't hear me, but I can't hear you that well either.
We can actually hear you, Janae.
Does it work better if I turn my camera off?
We hear you fine, but
Oh, great, because I can't hear anything. But that's fine.
okay, can you hear us now?
I heard you make that comment, but that was the only one.
Okay. Are you hearing us now? Okay. All right, let's start over with this exhibit, please.
I'm sorry.
As far as the identification of the exhibit.
Okay, Ms.
Ma'am,
Stewart,
ma'am, if you would go ahead and state your answer as to what this picture shows.
Yes, the picture on the first page is a picture of a gun in the couch.
and what is on the second page? Scroll down. If you can identify that.
The picture of some of Adam's guns, but this is how he was transporting them to the apartment when he moved out.
I'd like to tender petitioners E. There's no objection.
All right, any objection, Ms. Robinson? Ms. Robinson?
I'm sorry. It's really delayed. I do apologize. In regards to this, if you can hear me.
Yes, we can hear you now. You froze up for a minute. All right,
As did y'all for me as well. So
okay, she just tendered this exhibit. Do you have any objection?
okay. Not at this time. No objections, Your Honor.
Okay, admitted without objection. Anything else, Ms. Shockley?
One more thing, Your Honor. I'd like to see Exhibit B, please. Petitioner's Exhibit B. Dog is going crazy in the background. This has just really been an entertaining event. And could you identify this?
I'm trying to block out their email addresses.
For the record, Ms. Stewart,
Yeah, this is a copy of our family, some of our family wizard messages.
okay. And can you explain to the court very quickly why we chose to select this this particular outtake, shall I say, of our family wizard communications?
Yeah, the full communications are probably around 100 pages. So the first page of this is just all our family wizard messages from after Adam had been officially served with the TPO. Actually, the first 2 pages
So
are that.
okay. And so you were not responding because he had been served with the TPO, correct?
Correct.
And then could you flip to, I think it is the third page. The date is 1/13/2023. So this was prior to him having been served. Can you read that?
Yeah, this is prior to me filing for the TPO.
This was right before you filed, correct?
Yeah, this was the morning of that. Where, yeah, I had, I essentially in my communication, I told him that, essentially I said I cowered to his threats yesterday and I handed Harrison over at 2 p.m. That will not happen again. I was telling him, if he causes Harrison to miss the appointment, I would call the police and I would bill him for the appointment. And that's when he responds that a false report is a serious crime.
All right, and that was the incident that you were discussing earlier about him threatening you and saying that he wanted the child right away, et cetera, correct?
Yes. Mm-hmm.
And then could you flip to, the date is 1/12/23.
What's the page number? I'm sorry.
Sorry, it says 1 of 2 at the bottom. I wish these were
2, 3.
Hold,
It should be
hold on,
page 5.
hold on. I think we've lost Miss Robinson again.
Come on, lady. What the heck's going on? Also, I think you guys are going to be disappointed in the doctor mom for her gun safe or pew pew safety.
That's our heart. So frustrating.
Welcome back. Can you hear us? Okay.
Yeah.
All right, Ms. Robinson, I'm not sure what the issues are, the technical issues, because I'm not very tech savvy myself.
Neither. I went to law school for a reason.
Well, that's why I avoided math classes too. So, if this continues, I may have no alternative but to, on the court's own motion, because we've started this hearing in a timely fashion as required by law. I can continue this hearing until a later date, and the ex parte order will remain in effect until that time. I can't keep having the dropped calls here, or dropped videos or whatever, but the drop connections, because I got 2 other cases that are coming in this afternoon. They may already be here for all I know. And this was originally going to take about an hour and a half, and we're at that point now. And I realize you haven't even had an opportunity to get to your side of the case, so it's and I'm not holding that against you, anything like that, or against the petitioner, because we've had a lot of delays. Let's see how we go, and if it continues, then I may have no alternative but to move this to March the 1st to finish it.
Okay, Your Honor, I will say that in the event, as you had stated previously, if we needed to report back at a later time, I can go home where I know I have a very stable internet connection as opposed to here, so that we could proceed today if that would be something you'd be open to. I only live 20 minutes away, so it wouldn't be extended delay if you were to hear another case in that interim, but I definitely understand and
well, it's certainly my goal to finish it today. If we can figure out a way to do that'll actually work, then we may try that as an alternative. But let's see how far we go now.
Okay, yes,
maybe you need to upgrade your Wi-Fi.
I will tell my boss that. I definitely will.
Somebody needs to.
Yes, because the whole office is down, so I do apologize.
Okay, so
Who's your carrier?
I think it's Xfinity.
Okay, that explains it.
Yes.
All right, Ms. Shockley, you're back on.
yes, picking back up with Exhibit B, could you please, Ms. Stewart, walk us through, and this is so that the court understands this goes in backwards in chronology, correct? So the exchange that starts at the bottom, or actually on the next page. I'm sorry, guys, that these aren't numbered. It would be page 2 of 2 for the court reporter's purpose, but it's just simply the next page. Thank you so much. Could you tell us a little bit about what you were discussing here and how this ultimately ended? Just give us the background of what was going on, and then if you could read your last text message, which was actually the first text message at the top of the last page, to explain the issue right the day before you filed the TPO.
So this is the day there was inclement weather, daycare closed early. I picked up Harrison from daycare, as Adam's time does not start until 4 p.m. per our agreement. He was upset about this, and then that's what led to our exchange in my driveway, where he was threatening me, demanding to see the child. I felt like he was threatening to harm me if I did not comply, so I did comply. And then on the other page, the page we were just on,
Excuse me, if I may, has this piece of evidence, has this exhibit been entered into evidence? I'm sorry for my connectivity.
You have not tendered this page, have you? Exhibit B?
You know what? I think with all of the confusion, I think I've in my head forgotten to tender it.
Okay.
It was
All right. Would you like to tender it at this time?
Yes, I would like to tender it at this time.
All right. Any objection, Ms. Robinson?
Yes, we would just object to relevance. This has no bearing on the family violence issue.
I just
This nature, in which we're supposed to be here to handle.
All right, Ms. Shockley, your response.
This is a contemporaneous statement of right before she filed for her the actual entry that I'm about to have her read, and there's another entry that is very, very relevant and indeed goes to the threat on her life.
Well, you've stated what the threat was. I've not heard any evidence of that. I will overrule the objection to the extent that it relates to a conversation in the driveway. Now I want to hear what the conversation was. So I'm going to overrule the objection to the document as it leads to something that may be relevant. We'll see.
Okay, yes, sir.
Okay, thank you. All right, if you wish to continue with your examination regarding the incident in the driveway.
Yes, so you can continue your explanation, Ms. Stewart.
Yeah, if you scroll up to the top of this page. Yeah, so the message I sent at 2:39 p.m. was after Adam had left with Harrison after the incident in the driveway where he was threatening me. And I'm sorry I don't have a recording of that. I don't tend to go around recording my conversations with people. But I did put in here, I woke up a sleeping child because you demanded it. I hope you're happy. Per the parenting plan agreement, your time starts at 4 p.m. on Thursdays, not release to daycare. Do not ever threaten me again, or I will call the police about your erratic and dangerous behavior.
Ma'am, what are you alleging the threat actually was? You've used the word threat twice in describing the incident, but I have no idea what the threat was. Was it a threat for legal action? Was it a threat of bodily harm? You have to be specific, please.
Okay. It's a threat that things will happen to me if I do not follow his commands and comply with him.
It's the continual use throughout these correspondence that you see of, you have no idea what I'm capable of, what I will do. There's never a direct threat, which goes, frankly, Your Honor, there are direct threats, but in my mind, that's how I read them. But I think it also goes to the fact that he knows how to walk that fine line of saying, you have no idea what I'm going to do, instead of putting in writing.
Ma'am, Ms. Shockley, you're testifying now.
I apologize, Your Honor.
Yeah.
Y'all save all of this for argument.
So when he says things to me like, you better do what I ask you to, don't test me, don't push me, Courtney, don't test me, as he, as somebody who has lived with him and knows that he has a temper and has acted out before, and as somebody who knows that he is a police officer and carries a gun on him at all times, when he threatens me verbally, I take it as him threatening me physically because he carries a gun on him and he could choose to pull that gun out at any time. Because he does have a police background, he is very careful in how he words his threats and how he behaves when he does think he's being recorded or he does think things are being monitored. So my only defense to that is to put it in writing when something has happened to inform him, like, this is my documentation that you threatened me.
All right. Anything else, Ms. Shockley?
Just one final thing to that point. Let's see if you could just scroll down, Madam Court Reporter, and I will tell you where to stop. That might be the easiest thing to do. Right here, just right there. That's perfect. Okay. All right. So could you please remind the court of the context as to when this threat was made and then the reason why you put it in your correspondence in Our Family Wizard.
Right. So this is January 2nd. This is the day after Adam returned Harrison from his holiday time with him. We had just had a FaceTime with him. He wanted more time with him. I hung up on him because he had verbally threatened to kill me. And so I put that in writing saying, please, I do not want to talk to you on the phone. Earlier today, you threatened to kill me. I thought yesterday we made progress towards a better place. And then today the emotional volatility kicked in.
Thank you. Okay, I believe we're done with that exhibit. Okay. All right, Your Honor, I believe I will conclude my direct with.
Okay. All right, Ms. Robinson, before we start cross, let me ask my staff, have we heard anything about position 1?
Yes, Your Honor, no problem.
Yes, all the parties are here.
Parties and counsel?
Yes.
Okay. All right, well, I hate to lose the good connection we have right now.
It's okay. I can promise you when I run home, the connection will be much better. I'm an AT&T person myself, so hopefully that'll kind of get rid of those issues.
Well, let's go ahead and begin cross-examination. Well, hold on one second. I got a message here. Yeah, let me ask. I'm gonna take 2 or 3 minutes and speak with both counsel and parties in that case. Let them know that where we are in this, and I may give them some alternatives as well. Okay, so we're gonna ask. I'm gonna just place you in the waiting room, or the staff will. I won't. If I tried, there's no telling where you'd end up.
Understood. Thank you, Your Honor.
All right.
Well, that's the end of part 1, and I will get part 2 going right away. Thanks, guys.
So during direct examination, you kept repeating how you stated that Mr. Hawkins would say you would pay for things, correct?
Yes.
However, isn't it true that pursuant to the divorce decree and those messages in which you presented earlier that you were actually ordered to pay Mr. Hawkins a monetary amount, correct?
I was referring that he'll say you'll pay for things, meaning there will be a consequence to you. You will be harmed by his actions.
If you don't mind, I'm not asking for your interpretations of his statements. I'm just simply stating the facts.
And I'm clarifying my statement.
Hold on. first you answer yes or no, then you may clarify your answer. And she won't interrupt. You are entitled to clarify it, but start out, listen to her question, answer the specific question, and then explain it if you need to.
So I'll just start over just so we can start fresh. So you would agree with me that you stated that Mr. Hawkins said repeatedly that you would pay for things, correct?
Correct.
And irrespective of your interpretation of what he meant, isn't it a fact that in the divorce decree, you were ordered to pay Mr. Hawkins a monetary amount?
Yes. I paid him a monetary amount. He sold his custody rights away. I interpret when he says you will pay for things, meaning you will, as a threat, that you will be harmed by my actions if you do not comply with what I want you to do. He is not talking about money, in my opinion.
Well, let's actually talk about how you interpret these words in which you claim in which he's told to you. Now, you said on direct examination that you take it as it is him threatening you physically, correct?
Correct.
However, these are just verbal statements made to you, correct?
By someone who carries a gun at all times. Yes, correct.
Yes or no first, and then you clarify, okay?
Sorry, Your Honor. Yes, by someone who carries a gun at all times.
But he has never threatened you physically, correct?
Yes, he has.
He has threatened you with his gun?
No, he has not.
His gun? Has he ever threatened?
Give her time to answer. I can't
Oh,
hear
I'm
both
sorry.
of you at the same time. Okay, I
I'm
know
sorry.
there's a delay, so take a little extra time, please.
Yes, Your Honor. Mr. Hawkins has never threatened you with his gun, correct?
Correct.
He has never shot at you.
Correct.
He has never hit you with his gun.
Correct.
He has never hit your son with his gun.
Correct.
He has never threatened your son with his guns.
I can't speak to what happens when I'm not there.
But to the best of your knowledge, in your presence, Mr. Hawkins has never threatened your son with his gun, correct?
Not in my presence.
And so even though you take his statements as him threatening you physically, Mr. Hawkins has never threatened you physically with his gun that you claim he has on his persons at all times.
Not with his gun. That is correct.
All right, Ms. Robinson, I'm just gonna request that you not repeat questions. I'm pretty good at one time, I got it.
Yes,
Save it
Your
for
Honor.
argument. Thank
Yes, Your Honor. I'm ready to. Now, I also want to talk about a couple other circumstances. One being the doctor's appointment that you testified about on direct examination. Now, just to be clear for the court, at no point of time at the doctor's appointment did Mr. Hawkins threaten you.
Which doctor's appointment are you referring to?
That's what
On direct examination, you spoke about a doctor's appointment in which the two of you went to.
There have been a couple.
Was that on January 12th?
Correct. That is the one that you testified about on direct examination.
So you're referring to the appointments on the 13th of January then?
Yes, Your Honor. Yes. That you had testified about on direct examination, that particular doctor's appointment.
That particular doctor's appointment, the one that was canceled because of his behavior. Yes,
At no point of time. Oh, I'm sorry. Go ahead.
In the presence of the security officers who were present when we were in the same room, he did not threaten me in the presence of security. That is correct.
And while you were there at that doctor's appointment on January 13th, you did not call the police against Mr. Hawkins for any type of violent behavior against you, correct?
Correct. However, I had called them earlier and they had told me it was a civil matter and they could not do anything or help me. Therefore, I did not feel that they would be helpful if I called them again.
Well, let's actually talk about that civil matter. Now, on direct examination and as well as your petition, you had mentioned how Mr. Hawkins did not inform you about the whereabouts of your son on January 13th, correct?
Correct.
And that was in violation of the parenting plan, correct?
In the law, as I understand it, yes.
Correct. And that parenting plan was issued from your divorce decree,
That is correct.
correct? And you also mentioned about Mr. Hawkins supposed to retrieve the gun safe from your home, correct?
Correct.
And that gun safe provision was also in the settlement agreement for your divorce.
I believe so. I would have to review the exact wording of the decree.
And you also, I'm sorry, go ahead, Ms. Shockley.
I was just going to clarify that it is, I'm not sure whether it's in the parenting plan or the settlement agreement.
And you would also agree with me that on direct examination, you stated that Mr. Hawkins did not comply with the gun provision in regards to providing you with the serial numbers and inventories for his firearms, correct?
Correct. He has not complied with any court order to date.
And those are all the court orders from your divorce, just so we're clear.
He has not complied with the TPO, which is not from the divorce. So no, not just the
I'm
divorce.
asking about these particular circumstances in regards to the guns, in regards to the gun safe, and in regards to the parenting time. All three of those, you would agree with me, are in violation of the divorce decree, correct?
Yes, and the guns are also in violation of the current TPO.
I'm talking about the inventory, Ms. Stewart, the inventory in which the divorce decree was instructed him to provide that information to you. That was not in this protective order, correct?
In the protective order, he was ordered to turn the guns over to law enforcement.
Ms. Stewart, I'm asking about you testifying on direct examination, how you took issue with Mr. Hawkins not providing you with an inventory of the firearms. And that is in violation of the documents from your divorce, correct?
Ms. Robinson,
Correct.
the court,
You would agree with me
Ms.
that-
Robinson, hold on. Ms. Robinson, I got it, okay? The inventory was in the divorce,
Correct.
okay? Which is not all that relevant to what we're doing here today. The failure to turn over guns pursuant to this court's order in the TPO, in the ex parte order, that is relevant. Okay, and I've got the answer to both. I've already heard it.
Yes, Your Honor.
Okay,
So you would agree with me that Mr. Hawkins is in contempt of the divorce documents, correct?
Yes, as well as in violation of the TPO. I would agree with both of those things.
So now I would like to talk to you just a little bit more in detail about.
Can we just laugh for a minute at the judge's face there? I want to go back 10 seconds. Just watch it without the
the
volume.
answer to both. I've already heard it.
Yes,
Oh,
Your Honor.
so he just told her, I already heard it. Don't say that again. And then she goes on and asks this question again. Face palm. Literal face palm. Oh my god.
Yes, as well as in violation of the TPO. I would agree with both of those things.
So now I would like to talk to you just a little bit more in detail about Mr. Hawkins' actions since you filed this TPO. Now, you would agree with me that since the filing of this TPO, you have communicated with Mr. Hawkins, correct?
Yes, until he was officially served, because the advice of counsel was to continue to act according to our parenting plan and information until he is served with the TPO. That it did not go into effect till he was officially served.
And on the date in which there was an affidavit of service entered, you also communicated with him via our Family Wizard app, correct?
Not after he was served. No, that's incorrect.
On the date he was served on January 26th, you did communicate with Mr. Hawkins via our Family Wizard, correct?
Not after he was served.
And you would agree with me that on February 1st.
Hold on a second. All right. Ma'am, I understood you to say that you did communicate with him the day of service through the Family Wizard app. Now, whether or not that was before, I don't know what time of day the service occurred, but did you not testify that you did communicate with him one time on the date of service?
Your Honor, I did communicate with him on the date of service prior to him being officially served. Once that happened, I did not communicate with him.
I was never informed of the time of the service, so I had no idea whether it was before or after.
It was approximately at 4 p.m. So communicate. Yes, sir. On the 26th.
Okay. All right. Go ahead, Ms. Robinson. Sorry to interrupt. I just wanted to clarify what I thought I understood from direct.
Yes, Your Honor. And you would agree with me that you also called Mr. Hawkins on February 1st, 2023, correct?
Yes, as I explained earlier, that was when I was taking screenshots of the photos of the calls he had made after he was officially served. And it was a misclick, and it was less than 1 second and did not connect. It was not an attempt to communicate with him. It was an attempt to document his communications with me post-service.
Yes. As we proceed, give me one moment. Okay, now I want to talk to you about used two's interactions from the time that you filed this TPO, and from the time the ex parte hearing was served. Now, you already have stated that you communicated with him as usual until you received word that he was served, correct?
Correct. Additionally, between the time I filed the petition, there was about a week before my ex parte hearing as well. So it was not granted until January 19th.
Yes, but during that time, you were communicating with Mr. Hawkins, correct?
Yes.
And during those communications, you talked about how to care for your minor son after he had his ear procedure.
Correct.
And you also agreed to meet with Mr. Hawkins at a park to do the custody exchange, correct?
Which date are you referring to?
On January 22nd, 2023.
Yes, that is correct, because he was going to be served by the process server at that time. However, he showed up at my front door hours before the meeting time.
However, Ms. Hawkins, I'm just talking to you about the exchange that you two had, that you were able to have an exchange on January 22nd of 2023, correct?
Yes, and I just explained the exchange, and also, and my last name is Stewart, not Hawkins.
I do apologize. That is my apologies, Ms. Stewart. However, at no point in time during that custody exchange did Mr. Hawkins harm you.
He did not harm me. However, he did tell me he was aware the TPO had been filed and that it was going to harm him and cause lots of damages to myself and Harrison if I did not dismiss it.
However, he did not threaten your safety when he informed you of this, did he?
No, he had previously threatened to kill me on a different date. He did not engage that same words on that day.
I'm talking about this day in particular. And at no point in time during this exchange did you call the police.
I did not call the police. He had not been served with the order. They couldn't have done anything to help me at that point in time. Additionally, he has several friends who are on the Brookhaven Police Force. Therefore, I do not feel safe calling them because that has backfired before, where his friends have come and not listen to me because they're protecting a fellow officer.
However, I just want to be clear for the court's sake that there was no circumstances that led you to call the police against Mr. Hawkins on January 22nd, 2019.
Correct. I did not have, he was not served with the TPO. The police would not have been able to do anything for me at that point in time.
However, you didn't call the police to make a police report that he had threatened you, that he had harmed you in any way, correct? Because he had not.
Not on January 22nd.
And now I do want to talk about this threat that you keep mentioning. Now, you mentioned that Mr. Hawkins threatened to kill you on FaceTime, correct?
On FaceTime and then over the phone. It has been more than one occasion.
However, at no point in time, and I understand that you heard all of your conversations, but at no point in time do you have any record of him threatening your life.
No, I do not know how to record a FaceTime call. For our divorce decree, he gets a call with our son every night. So no, I do not know how to record a FaceTime call. That is beyond my knowledge of iPhones.
And Mr. Hawkins has never threatened to kill you in front of any other party or any other person, correct?
No.
And so no one would be able to support your allegation that Mr. Hawkins has threatened to kill you, correct?
No, we have not been together with a third party, since in a year, I would guess, with a third party present.
And the only instances in which you two interact relates to your son, correct? Physically, that you two physically see each other is in relation to your son, correct?
No, that's incorrect because Adam will show up at my front door to physically interact during times that are not his custody times with our son.
Now, I do want to talk about that front door. On direct examination, you stated that you have a security camera on your front door, correct?
I have a video doorbell, yes.
However, you also stated that you turned that camera off. Isn't that right, Ms. Stewart?
Yes, because Adam had access to my network. So I didn't feel that my video camera footage was safe with somebody whose job is reviewing and editing video surveillance footage.
However, you have no evidence of Mr. Hawkins hacking into this security system as you allege.
No, I only know he's read my texts and my emails, which for somebody who doesn't live in my house, I don't understand how else he's able to do that.
But you have no evidence of him hacking into your front doorbell camera, correct?
Correct. I have no direct evidence of that.
And you would also agree with me that this front doorbell camera is used for security measures.
Yes, it's a video doorbell camera.
And even though you claim that Mr. Hawkins shows up to your door and your house unannounced and that he's threatened to kill you, even when it is time for him to possibly come to your house, you do not have your camera on. Isn't that right?
That is incorrect. I disconnected the doorbell. I didn't say I disconnected the video portion of it.
However, on direct examination, you stated that you disconnected the doorbell camera so that you didn't have to know or see Mr. Hawkins on your front doorstep. Isn't that right?
Incorrect. I said I disconnected the doorbell. I did not specify the camera portion. And that way I am unaware if somebody is at my front door in real time. The doorbell does not ring. I do not know that somebody is standing on my front door. I'm not actively monitoring the camera portion of the doorbell when I'm at home with our young child. I'm taking care of the child. So I disconnected the audio portion, not the video portion.
But you don't have any videos of Mr. Hawkins showing up to your residence unannounced.
I would have to search through the video history to find those. Again, there would not be audio, so I don't know the exact value of that evidence.
But you haven't presented any of that evidence, irrespective of how the court views that value, here today during your testimony.
I have not provided any videos. That is correct.
Okay, now just a few last questions. just so we can wrap things up here for the sake of efficiently. Now, during, since your divorce has been finalized, you have never called the police in regards to safety concerns about your son while he is with Mr. Hawkins.
That is correct.
And you have never called the Department of Children and Family Services to try to indicate that your son is in danger while he is with Mr. Hawkins.
That is correct. I have not. I've done a lot of things out of respect for his job and because I do not want to ruin his life. I just want safety for myself and my son.
But at no point of time has any circumstances arose that would warrant you calling 911 because Mr. Hawkins has put your son in danger, correct?
I did call 911 when he didn't return my son and I had no idea where my son's whereabouts was. I did feel that he could be in danger and that's why I did call the police on January 13th.
But apart from that issue with the parenting time exchange, you have never called the police to state that Mr. Hawkins has harmed your son, correct?
No, I haven't. Again, he is friends with the police in our area. So the utility of calling the police is low in my opinion.
Now, I also want to talk to you about the guns that you had brought up on direct examination. Now, that picture, I cannot remember the letter, but respondents, I apologize for the
That's okay. E.
Okay, yes, respondents E. If the court would be so kind to bring that up.
Petition or the respondent E?
Petition.
Petition, okay.
It has already been tendered into evidence. Now, just so we're clear, this picture was taken while you and Mr. Hawkins were married, correct?
No, I had filed for divorce at this point.
But you two were still
The divorce had not been granted, is that correct?
That's correct. The divorce had not been granted, Your Honor.
Okay. Then you're still married.
Unfortunately, yes.
And this picture was in the basement of the marital residence, correct?
That is correct.
And so this picture of this couch was not taken at Mr. Hawkins' current residence, correct?
Correct.
You've never been to Mr. Hawkins' current residence inside, correct?
Yes, I have.
And have you ever seen, and you have never seen a firearm in this capacity? You have no picture of a firearm loose in his current home, correct?
You are correct that I do not have a picture. The day I was there were firearms on the kitchen counter. So yes, there was a firearm loose. I did not document it with a picture. That is correct.
And you didn't present any of that evidence today during your testimony, correct?
I do not have a picture of it on his kitchen counter to present. But yes, the one time I've been there, inside the apartment, there were guns unsecured on the kitchen counter.
And you've only been to his residence one time, which means you have no idea of how many firearms are in his home currently, correct?
That is correct. I have no idea. Because he did not provide an affidavit of his guns.
And you have no idea of the way in which he safely manages his guns in his home, correct?
All I know is he's told me he keeps them in the closet. That is what I only know from his accounting of where they are. So no. And I also know that he did not move the gun safe to appropriately lock and secure them. So that's all the information I have about the guns.
And the gun safe is currently at your residence at this time?
Yes.
Now, and you know what? No further questions. Thank you so much, Ms. Stewart.
All right. Any redirect?
No, Your Honor.
All right. Any other witnesses for the petitioner?
No, Your Honor.
All right. Ms. Robinson?
Yes, at this time, if this court is so open, we would just move that the petitioner's petition for a protective order be dismissed as they have failed to meet their burden or provide substantial evidence to meet their burden of proof to prove that a family violence incident has taken place here, or that Miss Stewart, is in fear of her harm or safety due to Mr. Hawkins' actions.
Ms. Shockley?
There has been multiple pieces of evidence submitted that would indicate that she is in fear of her life, that she has had her life threatened. She has articulated that she is afraid for her life, that there has been violence. I don't think that there's any space for a dismissal.
All right, Ms. Robinson, motion is denied. You may proceed.
Yes. At this time, the respondent would like to call Mr. Harry Hawkins.
All right, if you'll swear him in, please.
Please raise your right hand, Mr. Hawkins. Do you swear to tell the truth, nothing but the truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand down. Please state your full name for the court.
Yes, ma'am. It's Harry Adam Hawkins.
And were you previously married to Miss Courtney Stewart?
Yes.
How long were you two married?
2 years.
And before you were married, how long were you two together?
Approximately 5 years.
And at any point during your relationship with Miss Stewart, did you physically harm her?
No.
Did you ever threaten her with your gun?
No.
Did you ever hit her?
No.
Did you ever shove her with your infant son in her arms as she claimed?
No.
And have you ever threatened to kill Miss Stewart?
No.
Now, during your divorce case, did Miss Stewart ever mention that you threatened or harmed her?
No.
And has she ever taken a protective order against you in the past?
No.
Did she ever mention that she feared that you would harm your son during the divorce proceeding?
No.
And has anyone ever taken out a TPO against you in the past?
No.
Have you ever been convicted of any domestic violence charges?
No.
Have you ever been convicted of any violent crime?
No.
And do you have any type of criminal history or record?
No.
What do you do for a living, Mr. Hawkins?
I am a law enforcement officer for Georgia State University, and I work in the Department of Emergency Management. I oversee the drone program for the university and also a lot of the technology related to the police department.
And prior to this position in emergency management, were you ever in law enforcement?
Yes.
And how long?
I've been in law enforcement for 20 years.
And is handling a firearm part of your duties as someone in law enforcement?
Yes.
Are you aware of the risk that firearms have?
Yes.
And are you aware of the proper safety procedures in regards to handling and storing firearms?
Yes.
And when...
I just got to jump in and say here, he's going to regret those answers and how he is trying to come across, I think. Because if you remember, the petitioner said that he hasn't followed the TPO requirements of turning in his weapons. So it should be interesting to see how that's handled. Just a little thing to look for.
You have parenting time with your son, do you ever have guns out accessible to his reach?
No.
Have you ever had any type of guns around your son for him to access?
No.
Have you ever left your son alone with your firearms?
No.
Now, I want to talk to you a little bit about the impact that this matter has on your job. Now, what impact would a protective order have on your employment as someone in law enforcement?
It would cause me to lose my Second Amendment right, the right to bear arms. And with that alone, I would not be able to be in law enforcement.
And has your employer expressed to you that you would have consequences to your job should this order be granted?
Yes.
To the best of your knowledge, is Ms. Stewart aware of these consequences?
I believe, yes, she is.
I'm gonna have to object to the extent that this is calling for hearsay. There's no direct proof. The best evidence is not present. It's him saying that it's an issue is not exactly proof that it's an issue in my mind.
All right, Ms. Robinson, your response?
In regards to Mr. Hawkins or Ms. Stewart's knowledge of the implication that this has on Mr. Hawkins' employment, Ms. Stewart just testified on cross-examination that Mr. Hawkins made her aware of the implications this has on his job. And so therefore it is well within his reach, and something that has already been elicited from the testimony today.
Well, the previous question was more hearsay than this, but this question was based upon an alleged hearsay statement to your client who may or may not have related it to the petitioner, which you didn't cross-examine her regarding that, I don't believe. So I'm going to sustain the objection and let's keep the hearsay out.
Yes, Your Honor. I'm slightly confused in regards to the hearsay part that's stricken. Was it the portion in regards to Ms. Stewart's knowledge, or what was informed to him by his employer? Because that was my last question, was Ms. Stewart's knowledge of the impacts that this would have on his employment.
You were asking him if she had knowledge of something that would have been based upon what his employer may or may not have told him.
Yes, Your Honor. So, Mr.
It's not hearsay for him to testify as to what he has allegedly told her. Now, whether he's done that or not, I don't know. You ask him if she had knowledge of it. That's all you ask.
Yes, Your Honor.
And the relevance of it, I don't make my decisions based upon the consequences. The chips fall where they may when we have a hearing and I issue an order.
Yes, Your Honor.
Okay, go ahead.
Now, Mr. Hawkins, what impact has this order had on your relationship with your son?
Well, since the TPO has been filed, as of today, I've missed 24 days with my son. I haven't been able to see him, and the last contact that I actually had on the day that I was supposed to pick him up on my parenting day, and Courtney didn't show up. That was a day that he was actually sick and had went to the doctor that day. And I was there to pick him up as well because he had been with childcare throughout the day, I guess, while she was at work. And that's why he wasn't at daycare, why I wasn't picking him up at daycare. And then that's when the incident happened, where a vehicle drives by my car while my vehicle's in motion and throws something at the side of my car. And on that day, I called Courtney to ask her, how much longer she was going to be, and I have not heard anything from her since that day. So the last contact I had with Courtney in the parenting app in reference to my parenting time was that he was sick, and I've just reached out to her since then to just check on the welfare of Harrison, which is documented on the My Family Wizard.
And was this on January 26th of 2023?
I believe. Are you talking about the last day that I saw Harrison, or are you talking about the day of the day of the custody exchange? My custody exchange.
Correct. The day in which your custody exchange was supposed to happen.
Correct.
Ms. Stewart. Was this on January 26th?
Yes.
And would you recognize a copy of the messages exchanged between you two from our family wizard?
Yes.
At this time, Your Honor, the respondents would like for the court to bring up Respondents Exhibit 2.
I remember there's some personal information that she brings up. I'm gonna try and I don't know, right or something. We'll see what I can manage.
Now, Mr. Hawkins, is this the correspondence between you and Ms. Stewart relating to that visitation on January 26, 2023?
Do we have the specific
Scroll down.
page number that would,
Yes, if you, I do apologize. If you would scroll down to page 13. Sorry, it's looking a little weird.
okay, there's page 13. Is that the
Okay,
page?
yes.
you need? Okay.
Yes, Your Honor. Mr. Hawkins, are these the messages that were exchanged between you and Ms. Stewart on January 26, 2023?
Yes.
Do they appear to be a fair and accurate copy of these messages?
Yes.
Have they appeared to be changed or altered in any way since the last time in which you saw them?
No.
At this point in time, Your Honor, we would request that Respondents Exhibit 2 be tendered into evidence.
Any objection, Ms. Shockley?
No objection. I shouldn't have on my mute. Sorry.
I saw your head nodding, but couldn't hear it. Okay, it's admitted without objection.
So just to be clear, on January 26, you and Ms. Stewart agreed to meet at the park at 4 p.m.
Yes.
And at no point of time did Ms. Stewart inform you that she filed a protective order against you.
No.
And you can go ahead and take the messages down. Thank you. And at no point of time did Ms. Stewart tell you that she would have someone come along to the pickup location, correct?
Correct.
Has Ms. Stewart ever had a third party or law enforcement officer present during the custody exchanges?
No.
And and now I want to talk to you about the custody exchange on January 22nd, 2023. Now, when you exchanged your son after your visitation time, did you threaten Ms. Stewart at that time?
So the 22nd, that was Sunday. Okay, so no.
And at that time, were you aware that Ms. Stewart had filed a protective order against you? Had filed for a petition for a protective order against you?
On the 22nd?
Yes.
Yes. On the 22nd, I believe so. Let me see here. Actually, I don't remember the exact date that I was aware of it. So it might have been, I'm not certain the exact date.
And that's all right. However, at the last custody exchange, did she make any indication to you that she felt at risk of her safety during that time?
No.
Did she call the police after you two's interactions?
No.
Has she ever called the police against you for harming her?
No.
Have you ever called the police against her for harming you?
Yes.
And what happened during that incident?
So that was back after we had she had she had filed what was declared a false emergency hearing during our divorce. And at that time, the judge immediately entered in an
Relevant.
order.
So I heard a noise. I didn't know if somebody froze up or is everybody
Oh,
still
I'm
with us?
sorry. Objection, Your Honor, relevance. I'm not sure what the hearing in the, there's no evidence that, I mean, that's hearsay that there was a quote false emergency hearing. That's hearsay as well. And
Yes,
there's
Your Honor.
there's no court record of that is my point.
If I may proffer,
I'm sorry. Go ahead, Ms. Robinson. Your
if I may
response.
if I may proffer, we're just going to talk about the circumstances in regards to the physical altercation in which Ms. Stewart had.
Okay, well, that was where I thought you were headed, but I don't need to know whether there was a court order, not a court order, whatever. Was there or was there not a confrontation? That's
Yes,
all
sir.
I need to hear.
Yes. And when this took place, did Ms. Stewart physically harm you?
Yes.
What did she do?
So she restricted my access into the home through the garage door. And as she was holding the door, she then opened it and then reached out and struck me with her hand. And I took a photo of where she hit me on my neck. And I think you have that in evidence. And then at that point, I contacted my lawyer about the incident and then immediately called the police.
And would you recognize the picture of the scratches and the injury on your neck if I were to show them to you in court today?
Yes.
At this time, may the court pull up what's been previously marked as Respondent's Exhibit 6? Now, Mr. Hawkins, is this a picture of the scratches in which Ms. Stewart left on your neck after that incident?
Yes.
Is this appeared to be a fair and accurate copy of the picture?
Yes.
Has it been changed or altered in any way since the last time you've seen it?
No.
At this point in time, Your Honor, we would request that Respondent's Exhibit 6 be tendered into evidence.
Ms. Shockley?
No objection, Your Honor.
All right, admitted without objection.
And so after Miss Stewart, physically harmed you on your neck and you called the police, did you try to harm her physically after that?
No.
Did you request that the police have her arrested as a result of her violent actions towards you?
Not directly. I just explained to them that, my understanding of the situation, being domestic violence, that when there is a primary aggressor, but I did not go into great extent. As a matter of fact, I did not even say that I was in law enforcement, and the times the police have been out to our home, I have never said I am in law enforcement whatsoever.
And to the best of your knowledge, has Miss Stewart ever filed a police report against you for your actions towards her?
Not to my knowledge.
So why do you believe that she filed this protective order against you if you have never threatened or harmed her?
That's a very great question. The only thing that I can conclude is there's a lot of this built up frustration from the divorce, from the settlement, and also it clearly appears to me, and just over the past year, that it's literally restricting my parenting time, and that's been the most difficult part about this whole process, is because all I want to do is just spend time with my son and be a dad, and I just feel like every time there's just something that she is able to do to restrict my parenting time, and this is just another example of that.
Okay. And just this one last matter before we wrap up here. Now, even after this protective order was filed against you, and even after that incident with the process server, has Ms. Stewart ever tried to contact you?
The only thing that I've seen, just the missed calls. I had missed calls on my office phone, which I took a screenshot of, and also missed calls on my cell phone.
And would you recognize a photocopy of the screenshot of that missed call?
Yes.
At this time, we would like to request the court to show what's been previously marked as Respondent's Exhibit 4.
Okay, I think that this part is okay, but it's actually very interesting because this evidence isn't as good as she thinks. But let's not dox anybody if their info is up, okay?
Now, Mr. Hawkins, this is a screenshot of the missed call in which you received from Ms. Stewart, correct?
Correct.
Has it been changed or altered in any way?
No.
And does it appear to be a fair and accurate copy of the missed call and your call log?
Yes.
At this time, we would request that Respondent's Exhibit 4 be tendered into evidence.
Shockley.
I have an objection to the extent that I cannot see the date or any sort of,
Okay, so there's the time. Okay, here we go. I was gonna ask that it be scrolled all the way down so we could see the whole thing.
Yes, but that is the full screenshot.
and could you let me know, let's see, all right, so this is
February 1st,
Who is
2000.
Who is Francis Springer?
I'm talking about what's been the Courtney Stewart, not the Francis Springer. So if you would like to constructively redact that portion of the screenshot, we would have no objection to doing so as well.
How do I?
I don't know how it can be removed.
Yeah, I understand. That's why I said constructively if so be, but we were just focused on the missed call from Ms. Stewart. And I also have another exhibit if need be, with confirmation that that is her actual phone number, and contact information if this court would like me to provide that information as well.
Well, what my problem with it is I can't tell when that call came in. There's something down here that says Wednesday, February 1st, and it's an image, but that's not that call.
That's the data screenshot.
Right. That's the day that he took the picture, because that's saying this is the day that like they always do when you've got a phone. But there's no way to see when that phone call that she allegedly made came in.
Yes, I have. If you look at the top, it has the timestamp in recents, 216 in recents, which states that that is of the most recent call. And considering the time of the screenshot at 2:16 p.m., that is the last missed call that Mr. Hawkins received.
It is more important for the court to see an alleged call as to when it was actually made, not when the screenshot was taken.
Yes, Your Honor. And if I can have Mr. Hawkins testify as to what date this was.
Well, I'm going to sustain the objection as to this document.
Yes, Your Honor.
If you have something else, which I think you said you did, then I'll be happy to look at that.
Yes, I have. Yes, at this time, may the court please bring up Respondent's Exhibit 3. And this is the proof that's in connection with that. In regards to the confirmation that that is actually Ms. Stewart's contact information, that was actually her calling, and it has the time in which that call was made on February 1st of 2023, and which is also the same conversation.
That is a misrepresentation.
That testified.
Hold on, both of you are talking at the same time here.
I'm gonna have to object. I see nothing, and we can scroll down, but I see nothing that indicates the date that this occurred.
That's critical. Is where does it show a date, Ms. Robinson?
Oh, I am
says-
not
It
contesting that
says
a
yeah.
date is
Okay, it
Yeah,
says
yes, Your
yesterday.
Honor,
That's all it says.
Yes, Your Honor, I'm not contesting that this document itself, that's why I did not tender this one into evidence to show that, because there's no date on this. The other document has a date on it, and I was just using this as support if the court wanted to see additional information. However, in regards to the specific date, it is only on Exhibit 4.
But that was the date of the screenshot, was it not?
Correct. The screenshot as well as the date in which the call was made or attempted to be made.
It doesn't show a date.
Okay, yes, Your Honor.
It showed a time, 2:16. And that was the time I understood that the screenshot was taken.
Yes, Your Honor.
Correct.
That is fine. We are able to proceed, and we are willing to proceed. If this
Okay,
court
all right.
decides to sustain the
Thank you.
objection. Now, Mr. Hawkins, as you heard on Ms. Stewart's direct examination in her cross, she admitted that she called you.
Yes.
And did she call you after you had that interaction with the process server on January 26, 2023?
Yes.
Did you answer when she
No.
called you?
No.
Have you called her since you have been served with that protective order? Or when the affidavit of service was entered for that protective order?
No.
Have you tried to text her or reach out to her via text message?
No.
And have you had any contact with her, any conversations with her since you were alerted about the service of this protective order?
No.
And during that time, have you ever threatened to harm Ms. Stewart since the finding out of this order?
No.
At this time, Your Honor, no further questions.
Any cross-examination?
Yes, Your Honor. Okay, Mr. Hawkins, you stated that after being aware of service, that you did not attempt to contact Ms. Stewart by phone. Is that correct?
Not by phone. This only through the parenting app.
So
It
you
was-
acknowledge that you attempted to contact her through the parenting app.
The only
There is a,
what I'm saying is the only correspondence. No, after I received notification from your law firm that there was an act that I had been served. No.
well, sir, were you not aware that you were served on January 26th?
No, ma'am.
You were not aware that you were served.
I-
You're a law enforcement officer.
I was not, ma'am. I was never giving any documents. Nothing was ever given to me.
Let's pretend for one moment that that was true. You testified a few moments ago that you were already aware of the TPO on the 22nd, and that would be because you were cyber stalking my client. Would that not be correct?
I said I wasn't aware of the exact date. The incident that occurred on the day that I was going to pick up Harrison on
Answer my question.
my custody exchange was a vehicle. I'm sorry. Go ahead.
Question
Just
mark.
as I instructed Ms. Stewart, start out, listen to the question, then answer yes or no, and then you may explain your answer, and she will not interrupt you while you're explaining.
Yes, Your Honor.
Your testimony just a few moments ago was that you were aware that there had been a TPO filed against you on January 22nd of 2023. That was before service was even perfected, but you testified that you already knew about it, and that is because you were cyber stalking my client. Is that,
Just one question at a time.
do you recall that testimony?
I said I don't recall. I do not recall the exact date of of when I had knowledge of it.
Okay, but you had knowledge of it as of the 26th. Is that not correct? At a very minimum, you had knowledge of it on the 26th.
I have to look at my dates. I mean, just from recollection, I do not have the exact date.
Date you were served. I'll represent to the
Yeah.
court. We'll be able to produce the affidavit if necessary.
Okay, so in reference to the service in which you're claiming that I was served, that incident is where I did not receive any documents. There's a vehicle that drives down the street and throws something at the side of my car, and I never received the documents.
Sir, that's not the answer. That's not the question. The question is, are you aware? Were you aware on the 26th of the TPO?
No, I was not aware of the. I was
All
not
right.
aware.
Okay,
Okay.
hold on, sir. I'm going to ask you a question.
Okay,
If you weren't served, how did you know who the law firm was?
because this was after the fact. This was after this incident. The law firm started emailing my job saying that I had been served, requesting my guns be turned over to my agency, and then they were saying that I had been served, and that was the time that I was aware that they're alleging that I was served, but I never received any documents, and it wasn't until later, like a few days.
Several hours ago, we proceeded with this hearing. Everybody was present, ready to proceed, and this is the first anyone has even mentioned that service was not perfected as required by law. Why are we hearing this several hours later?
She was asking me about my knowledge of being served, and I was explaining the incident of how it occurred. Like, I'd never actually received the documents when the documents were sent by her law firm to my job, and I was contacted by my job in reference to this TPO. That was the date, and that's when I found out about it, was through my job, when they emailed they emailed the legal team at Georgia State and the director of my department, and then I was contacted by my boss.
Respectfully, Your Honor, I have the affidavit of service. There has been no objection filed to the affidavit of service. I'm happy.
We're proceeding as if service was valid.
Right.
We're several hours into this, so.
Right. I'm not. We weren't.
You can certainly present the affidavit, but you can do that in rebuttal.
Okay.
All right, if you want to present it now, you're on cross. Go ahead. Whatever.
Respect, I guess is it court, the court can take judicial notice, I suppose, since it's on the record. If you would like me to tender it, however, I will. And that would be plaintiffs F, or not. Something happened with the way I have them numbered in a different way. I don't know what happened when they were sent over. Okay, it should be labeled affidavit. My apologies if the numbers got screwed up, but it should be.
It's Exhibit G.
Right, so they just got one off somehow in my things. Okay, all right. So I tender Exhibit G as a court record, an affidavit of service stating that Harry Adam Hawkins was served on the 22nd of January.
So I'm gonna take a moment here. I blanked out his address, but if we notice at the bottom, oh, his damn address is there too. Don't read here. I'm gonna read what it says on the bottom because I think he might actually have a point in a way. However, I think he's a liar, and so I'm not trying to help him anyway. But what it says in the additional comments, Successful attempt January 26, 2023, 4:05 p.m. Eastern Standard Time at address in Atlanta, Georgia. Received by Harry Adam Hawkins. Subject was parked in their vehicle at a park in a gray Dodge Charger. I parked next to the subject, opened my window to hand him summons. He drove off. Left summons by his car as he drove off. I don't know if that is service, but they didn't dispute it to begin with, so the judge already said he's taking it as service. But let's continue on.
At 4:05 p.m., which is already part of the court record.
Okay, all right, let's move on. Any objection, Ms. Robinson?
No objection, and as we have already proceeded and it's already been introduced.
Okay.
Okay, could we take a look at plaintiff's H, please?
Are you sure?
I'm adding one, so I think I'm.
Okay. All right.
All right. Okay. All right. Mr. Hawkins, is that your phone number?
Yes.
Okay. Do you have any reason to believe that these are not accurate screenshots of times that you called your ex-wife?
Those are accurate.
Okay. So I'm gonna.
Can we scroll down?
I'd like to tender Exhibit H as cell phone records or cell phone screenshots demonstrating contact to Ms. Stewart from Mr. Hawkins after having been served the process.
All right. Any objection, Ms. Robinson?
Not at this time, Your Honor.
All right, admitted without objection.
All right. I would now like to tender Exhibit I, or excuse me, I'd like to present Exhibit I for examination. Okay. Do you recognize this correspondence on the 13th of, I'm so sorry, could you scroll down just a little bit? Yeah. A little bit further. Okay. All right. Do you recognize this as correspondence between yourself and Ms. Stewart?
Yes.
Okay. And do you note that that you state that there has been no, well, I'll tender the exhibit.
Any objection, Ms. Robinson?
No objection, Your Honor.
All right, admitted without objection.
So you see at the very bottom there at 6:15, you say, I requested to see H on FaceTime and it's been 11 days and there's not a valid TPO. Do you see that?
Yes.
Did you write that?
Yes.
Okay. And why did you think there wasn't a valid TPO?
Like I stated before, because I have not been served with a TPO.
So you took it upon yourself to determine whether or not service was perfected, but you were obviously aware of it.
So I guess I need to clarify, like there's the TPO filing and being served. I think that's where it's getting confusing here. Like as Courtney.
There's no question pending.
All right. Well, just for my understanding of the chronology of events here, it's my understanding from testimony and from the record, it was filed on January 16th. It was heard by the ex parte judge on January 19th and granted on that date. But service, and we just saw the exhibit a minute ago. What was the date on the affidavit?
The 26th, Your Honor.
Okay. So this is from January 22nd, where there obviously has not been service, correct?
That is what it appears, Your Honor. And yet somehow he knows about the TPO. That was
If I may, the timestamps on the 3 of those documents are different. The very top says Sunday the
That's-
22nd,
that's true.
Friday, and then 15. So I just want to be clear for the court that that last text message is not supposed to be indicated as being from January 22nd, but instead from another date and time in which
Good point.
I
Uh,
accept
Well,
that.
each of the next two, one says Friday, which I don't know which order this goes in, from bottom to top or top to bottom.
Your Honor, I will agree with Ms. Robinson that it is impossible to tell which day that text came in. However,
It's not impossible. This bothers me so much. If you know how iPhones work, it would be Sunday, January 22nd, the Friday following that Sunday. And then today, if they just scrolled up to the top of this image to see the date at the top, that would indicate the date of today. But they're not. She's not the most tech savvy lawyer, I guess. But anyways, listen on. We're gonna get to a real good smackdown here soon.
I can get the information from my client on rebuttal shortly to provide that, I believe. But also, it does acknowledge that he's aware of a TPO and he's still contacting her.
Yeah, I don't know whether it's a date after January 22nd or a date before January 22nd.
Correct. And I believe my,
I'm not going to admit the document.
thank you, Your Honor.
Yes, Your Honor.
Mr. Hawkins, why do you believe that it is okay for you not to fulfill your obligations under court orders?
I don't understand. I don't understand the question. What?
Why have you not fulfilled your obligations under the divorce decree, which is a court order? You believe that you are above the law, correct?
No, ma'am.
Then why do you not obey court orders?
Can you give me an example of which court order you're referring to?
I can give you many examples. Why did you not relinquish your firearms when you were aware of the ex parte TPO?
I did.
No, you did not, sir. I challenge you to demonstrate to me, contact a law enforcement professional that can tell me that you did so.
Contact Georgia State University.
Okay. All right.
They took my firearm.
Sir, did your own counsel not state at the beginning of this hearing that you have alleged that they are not in your possession, but that you have not turned them over to law enforcement as required by the TPO?
I do not have any firearms in my possession, and the Georgia State University firearms, Georgia State University has.
What about the other 23 guns or 24? How many guns do you own, sir?
I don't own that many guns, and
How many do you say that you own?
I own 3 guns.
What happened to all the others that were in that picture?
I've given those to family members. Those are no longer. They are not at my apartment.
Has the registration
When did this occur, sir?
This occurred over a month ago. Well over a month ago.
have you changed the registration to your family members' names? Did you sell these guns?
No, I didn't. They actually, some of them belonged to my dad anyway. So I gave them back to my dad because I don't need to keep all those in my apartment. And the reason I don't have the gun safe is because the gun safe is way too big for my apartment. And so
Why did you agree in a negotiated settlement agreement to remove the gun safe and take it to your apartment and install it and keep the guns in the safe?
Objection, Your Honor, as to the relevance of this matter we're talking about.
Yeah, I'll sustain that objection in terms of why they negotiated something back in November or whenever, versus what they actually did. My concern is where those guns are now.
Yes, Your Honor, that's our concern as well, and we've got no proof of where they are.
Your Honor, I do not have any guns in my possession. The guns that you saw pictures of, those are at my parents' house. Those are with my dad.
And that's supposed to satisfy the requirement under the law and under the court order that you turn them over to law enforcement instead of your parents?
No, that was actually done before. That was done a month ago. This was done well before the court order.
So why did you suddenly give them to your parents?
Because Courtney kept bringing it up to me about constantly saying that, you know, I'm in contempt because I haven't provided her the serial numbers for my guns. And so I realized that the best thing to do was to get rid of them and give them to my family, and not keep them, because the agreement is that I had to provide her with the information of the guns that I had in my possession.
Okay, well, I'm going to ask a question.
Sure.
And I want a truthful answer, please. I understand the Georgia State gun is in the possession of Georgia State law enforcement.
Yes.
Which apparently you're the head of, or pretty close to it. Why was okay? What other guns have you purchased that are in your name? Tell me what they are. Tell me what kind of handguns and long guns you may possess or have in your name. Excuse me, not possess at this moment.
I have a Glock. I have two handguns. I have a Glock. I have a Glock. I have a 40. I have a 40 cal. They're two 40 caliber Glocks.
Okay. All right. What else?
That's it. And
how long did you have possession of all of these other guns before you gave them back to your dad? Years?
Yes.
Why did you have them? Were they given to you?
Yes, my dad. Some of them were my dad's, and before that, they were in the family. And so, when I talked to my parents about the situation, my dad agreed that I just give them back to him, and he would keep them at his house.
Where are your 240 caliber Glocks?
They're also right now. They're with my dad.
All right, go ahead.
Do you not also own some assault rifles, at least one?
Everything all the guns are with my father.
That's not the question.
Do you?
I asked you the question, and you said you only had the 240 caliber Glocks. Do you own a long gun? Do you own an assault rifle?
No, that's Georgia State's gun.
How many Georgia State guns did you at one point have possession of?
The gun that I'm referring to, the rifle was turned into Georgia State.
Okay, so it was a rifle. It was not a handgun.
Correct.
What did you wear around campus? One of the handguns?
So, yes, when I was working in that capacity.
What do you mean in that capacity?
When I had a handgun when I was in a uniform.
Okay, are you required to wear a uniform?
No.
Okay, so then you're not required to own a gun, to possess a gun if you can wear a suit and tie to do your job, are you?
I maintain my certification, and
That's fine. You can maintain your certification. You're talking about your post certification.
that, and also it gives me the ability to work extra jobs so I can make money.
Your post certification, you just have to take your training hours every year, right?
To maintain,
Your post certification.
yes, correct.
It doesn't require you to hold a gun, does it? I mean, you go to classes for post certification, correct?
Yes, that's correct. But I cannot be a police officer if I can't carry a gun.
So you can't work your side jobs, is what you're telling me.
What I'm telling you is I can't work. If anything, if they could call me in, if they need, extra boots on the ground, for example, and tell me that they need me, in that capacity.
They who? Georgia State?
That's it, yeah.
But you supervise all the officers, correct?
No. So I'm in emergency management. So the police department and emergency management work together, but the stuff that I do is more technology and drone related stuff.
Okay, so you do technology and you do emergency management.
Right.
Okay.
You don't
Do they
need
require a weapon?
They don't require a weapon.
Okay. All right, let's move on.
believe you already, in an effort to save time, you did testify that you did contact Ms. Stewart via Our Family Wizard on 126 and post 126, correct? We can pull up the exhibit again if we need to. In other words, after having been served with the TPO.
I did not have knowledge of being served until the service was emailed. The actual service was emailed from your law firm, and I have to pull up what that date was.
I have that email, and
Okay.
that date was the 27th. And so you still continued to contact her after that time, did you not?
So I did not, as soon as I had an affidavit of service, I did not contact Courtney.
So let me understand this. Papers were handed to you and you just drove away from them?
That's not at all what happened, and that's not what I stated earlier. I said I was driving, my vehicle was in motion, and a vehicle pulled up next to my vehicle and threw it at the side of my car while my vehicle was in motion. I never received it. My window was never rolled down. I don't know who the person was in the vehicle. I never received the documents.
Well, that's an inaccurate statement, obviously.
Okay, please don't argue with the witness.
Um,
Save it for argument.
That's all, Your Honor.
All right, any redirect, Ms. Robinson?
Very briefly, Your Honor. Mr. Hawkins,
Yes, ma'am.
have you ever stalked Ms. Stewart?
No.
Have you ever cyber stalked Ms. Stewart?
No.
Have you ever hacked into her email?
No.
Have you ever hacked into her text messages or iCloud protocols? I'm sorry, not technologically savvy, but
No.
her phone. Her phone. Have you ever hacked into her security system at her home, including her doorbell camera?
No.
And do you have access to her personal communications on your own?
No.
No further questions, Your Honor.
Any recross?
No, Your Honor.
All right. All right, any other evidence from respondent?
Not at this time, Your Honor. The respondent rests.
Okay, well, this is the only time, so we need to say not at this time. All right, closing arguments.
I'll reserve.
Oh, excuse me, I did not ask, did, you said something about rebuttal before?
No, Your Honor, I'm fine. I'll just reserve closing.
Okay, all right. Well, I meant as, not as to the arguments, I meant you had said something an hour or more ago about presenting rebuttal evidence.
I don't believe that's necessary at this time, Your
Okay,
Honor.
I just wanted to give you that opportunity before we went to arguments, so, since you had said something earlier, okay.
Good memory.
At my advanced age, I'm proud of it. All right,
Okay. I'm gonna make it number 3 its own video with the arguments and the judgment. So tune in.
so, I'm sorry, you reserved,
Yes, I reserve close.
okay. All right, Ms. Robinson.
Yes,
And let's please try to make it as brief as possible. And
yes, Your Honor, I will, I promise.
okay, thank you.
I will. May it please the court. There has been no evidence presented today that Mr. Hawkins has threatened to kill Ms. Stewart. The only evidence in which you heard was from her testimony herself. There was no evidence that he has showed up to her home unannounced, as she has stated. There's no evidence that he has cyber stalked her, that he has hacked into any of her technological information or devices. Only her words. There's been no evidence that he has ever harmed her, threatened her with his gun, even though she tells you that his words cause her to think that is a physical threat. But there has never been an instance in the past, iterated during divorce or after, in which she has stated that he has harmed her, has harmed their son, has threatened them with any type of physical violence or firearm, because it simply does not exist. The parties continue to communicate without issue via our family wizard in person after Ms. Stewart had filed this petition for protective order on January 13th. You heard from both witnesses today how on January 22nd, the two exchanged their son after a visitation. The police weren't called. There was no third party there to serve as a buffer. None of that was necessary, because at no point of time during the parties' relationship or after divorce is finalized has Mr. Hawkins ever posed a risk, a harm, or any type of danger to Ms. Stewart or their son. And although she has testified today about how she's in fear of her safety, she hasn't supported that. They have not met their burden by the evidentiary standard to prove that Mr. Hawkins, that is a danger to their safety, that the only way to protect Ms. Stewart is for this court to enter an order. Now, she testified before you today how the security measure that she has in her home, she voluntarily decided to turn it off. She claimed that he shows up to her house unannounced and knocks on the door and stalks her. However, she presented no evidence of such. Instead, she stated to the exact opposite, that she turned this camera off so that even though she initially said she didn't turn the camera off, she tried to state that she turned the doorbell off, but she's not using the security measure in which she had installed in her home to keep her home and herself safe, because at no point of time has Mr. Hawkins been a risk to her safety. If she was in actual fear of her safety, she would have done each and everything possible to try to protect herself. She would have called the police officers. She would have gone to the police station. She would have asked Mr. Hawkins to meet at more public locations with cameras instead of a park. She has presented no evidence of her doing anything to help with her fear, but tell the court that she's afraid. And that is because, Your Honor, all of these issues that you have heard today in regards to the gun safe, in regards to Mr. Hawkins not providing Ms. Stewart with an inventory of the guns, in regards to the issues with the parenting time that took place on January 13, 2023, all of those instances are proper for a contempt because they're in violation of the final judgment and decree and the subsequent documents that the parties obtained at the end of last year from their divorce decree. These are not proper for a protective order. There has been no evidence of violence on behalf of my client against Ms. Stewart shown today. She has admitted herself that these issues are in direct violation of the judgment and decree that was issued from their divorce. And therefore, the fact is that at no time has Mr. Hawkins been the aggressor, has had any type of domestic violence charges against him, or any domestic violence instances with him as the attacker. But instead, what you heard today was evidence of Ms. Stewart being the aggressor. You saw pictures of how she scratched his neck. Now, I want to be very clear for the court. When I had mentioned this incident very vaguely in my opening statements, I gave no detail, I gave no content. The only thing in which I told this court was that Ms. Stewart had physically harmed Mr. Hawkins. However, she came before you in her direct examination prior to me having the opportunity to question her about this incident, and she told you herself. She told you because she knew that it was true. Now, she also stated that she had claimed that the police told her that she could file a protective order or get some type of relief, but you heard her today in this court say that she didn't file any type of TPO or file a police report or even call the police after she erroneously claims that the police instructed her to seek some type of legal redress. She didn't do it, Your Honor, because at no point of time was she in fear of her safety. Throughout the entirety of the divorce, control has been an issue. She has tried to control the manner in which Mr. Hawkins interacts with his son, trying to control the entire situation. And her filing this TPO is just another instance, another mechanism of control in which she's trying to portray. She's trying to restrict Mr. Hawkins further from his parenting time. You heard it's been over 24 days since he's seen his son. Yet she has at no point of time called DFACS, the police, or any other third party to indicate that Mr. Hawkins is a fear, is a risk to their son's safety. And that is because, Your Honor, he is not. And therefore, we would respectfully request this court to deny the petitioner's request to have a protective order issued against Mr. Hawkins. We would request that this court deny any type of imposition of any type of penalties as a result of this action. And we would request that Ms. Stewart be responsible for Mr. Hawkins' attorney's fees as a result of this erroneous action. There has been no evidence presented that shows that Mr. Hawkins has threatened to kill Ms. Stewart, that he has threatened or posed any type of harm to their son, and therefore the grounds in which the petitioner is alleging these claims are improper. And therefore, we would just request that this court dismiss this TPO. Thank you.
Thank you. All right, Ms. Shockley.
Respectfully, Your Honor, words are evidence, testimony is evidence, and Ms. Robinson has acknowledged that there was significant testimony as to the threats to my client. And my client has been very clear in her testimony as to what those threats were, including the threat to take her life. I believe that when it comes down to words, we also have to then look at credibility and who is the credible witness. Every time that my client was asked something and there was the need to, quote, prove it up through any sort of backup document, we were able to do that. It was accurate to the extent that those documents or what have you, pictures existed. To her point, she doesn't video everything. She doesn't record every message or every interaction with her ex-husband. And she's not required to. That's simply not how she wants to live her life. Her life is already trying enough in dealing with a toddler and the constant harassment and stalking by Mr. Hawkins. I think that what we come down to, and in fact has been admitted, because they are acknowledging that he is in complete contempt of the divorce decree, is that Mr. Hawkins, he acknowledges himself, does not believe in rules. And he's in contempt. I mean, that's what they just said. He is in contempt, and he's in contempt because he doesn't think the rules apply to him. when asked, why didn't you turn over the guns like the order, required you to do it? Well, he didn't have an answer to that other than just, I guess he doesn't think the rules apply to him. He also tried to mislead this court and make them think that he had to have his guns to perform his job. That was absolutely inaccurate and when nailed down by yourself and myself, he had to acknowledge that he doesn't have to have guns to perform his duties. And I am sorry if he likes to have guns, which is what this just seems to be about, because we spent an awful lot of time trying to explain why we needed to keep our guns when they aren't needed for anything other than potentially harming my client. They're not needed for his job. He doesn't say that he hunts. There's no reason for him to be in possession of those weapons. With respect to the comment that my client was aware of what the circumstances were with respect to the domestic violence incident, that's correct because Miss Robinson asked her about it and then I redirected her. So that was the reason that came out. That wasn't because she knew what she was talking about. I mean, even if she did know that that's when he was what was being referred to, there was only one time that the police were called. But that was something that we dealt with on redirect. With respect to this concept that there are, quote, no issues with their correspondence, I would ask the court to look at the correspondence, to see where he calls her a fucking asshole, to see where she tells her you're going to pay for this, to see where he says that, this is not going to go well for you. You don't know what I'm capable of. You don't know what I will do. Where he degrades her, where he tells her that, this is all your fault. I would invite you to read those correspondence and decide whether that is interacting without issue. With respect to the exchange on the 22nd, I can assure you that my client was very nervous about that exchange. There are cameras in that park, and that is precisely one of the reasons why it was chosen. And they chose to go to a park because my client did not want it to occur in a private place. She is afraid. She has testified she is afraid. We have demonstrated that he is erratic. He is irrational. He does not believe that the rules apply to him, and he must be held accountable. He must be held accountable. He needs treatment for his temper. He needs treatment for his complete disrespect for the law, which is frankly astounding considering his background. One would think that he would respect the law, but what he does is he uses that knowledge to walk that line, and that's exactly what he's done. And he kept pointing to, well, I never said this, I never said that. No, you didn't say it in writing because you knew better than to do it. You didn't leave a mark because you knew better than to do it. And I respectfully, Your Honor, my client needs protection. Her child needs protection. We would ask that the 12-month be entered. This has gone on long enough. To the extent that she waited, we all know the statistics on that. People wait because they're afraid. And they don't want to elevate the situation. And as I stated earlier, she at night thinks to herself, if it gets entered, what happens? And if it doesn't get entered, what happens? Both of which scare her. And I think that that's all that we need to know. She knows that this is just a piece of paper, but it's better than nothing. Because when she has called on civil contempts, the police have told her there's nothing that they can do. And she has called on several different occasions, and nothing has happened. And so we need this TPO so that there can be immediate action taken. Don't think that we might not be filing a contempt as well, because obviously they've already acknowledged the contempts, and we probably need a modification of this divorce decree. But at a bare minimum, we need a 12-month protective order to keep my client safe and to allow her to return to some sort of normalcy in her life, hopefully. So we would ask that that order be entered with all of the provisions, including the removal of the firearms, including the program with the domestic violence, including the suspension of his visitation. It would be supervised until such time as at least he had completed the domestic violence portion of the order. And we would ask that he pay my attorney's fees and I can pull up the information as to exactly what those would be, for having to bring this, this order, or this TPO when he's blatantly acknowledged that he's in violation of orders. Thank you, Your Honor.
All right. Well, it's always a shame when I have two people who are well-spoken, who apparently at one time actually liked each other. And here we are today, this being the second piece of litigation that the two of you have been involved in. The other obviously took a while. You found a way somehow to enter a consent. Court orders do have meanings for everyone, and court orders are meant to be complied with. There are ramifications for failing to abide by court orders, such as contempt, such as criminal charges, misdemeanor, and possibly felonies for aggravated stalking for any violation of a temporary protective order. Any violation of a protective order can lead to criminal charges, not just contempt in front of a judge such as myself or the divorce judge, whoever handled that. The two of you are tied together for another, well, you think it's just for another 17 and a half or 16 and a half years. Like I said, I was never good in math. It doesn't stop at 16 and a half years when this child, who I assume both of you love dearly, I don't question that, either one of you. You actually liked each other at one point. You got married, you had a child. And that child's, how that child grows up will be determined solely by the two of you. Not solely, predominantly by the two of you. I'm going to assume the child actually loves both of you. I don't think I'm getting out on a limb there. I don't think either one of you would disagree with me on that. Ma'am, would you disagree with me that his name's Harrison, correct?
Yes, sir.
Okay. Would you disagree with me that he loves his dad?
I'm sure he does.
Sir, would you agree that he loves his mother as well? Both of you are capable of raising this child to a point where he will not end up in a domestic violence court. Domestic violence is a learned behavior. The studies have all proven that. And unless you want to be dealing with getting him out of jail down the road, as loving parents sometimes do, post bond, get him out of jail, or have to deal with testifying as a witness in his domestic violence hearings, or he could become a victim of domestic violence because if he sees that behavior from the two people he loves the most, he will repeat it in all likelihood. The two of you in raising this child need to put aside your now dislike for each other. I'm going a little beyond what is normally in any orders, but I'm telling you from years of experience as a domestic practice lawyer and as a judge, time and time again, that's what happens to children who witness this. And whatever it takes, you need to stop. Keep your adult issues between the adults and do it in a proper fashion. That's why we have judges. That's why we have lawyers. That's why we have courts. And they call them civil courts because it's a place where you can resolve your differences in a civil fashion. In an ideal world, doesn't always happen that way, as I'm sure both of your lawyers could attest. I can certainly attest to it from where I sit. But it's easy. The name calling, the blank you, all of that just compounds problems. It's gasoline on the fire. and it accomplishes nothing. Much has been made about the fact that the only evidence, well, not the only, but the predominant amount of evidence presented to the court was by the testimony of the two parties. I expected them to be in direct contradiction to one another. I would have been surprised if it had not been in contradiction to what each of them testified. It would have been helpful, obviously, for both sides to have more that they could have brought. We could have heard from the process server to rebut what we just heard a little while ago. We could have actually had the respondent's parents, or a parent, testify as to what's happened to these weapons, as to who owns these weapons. They would have had to do so under oath. I don't know. Is that why they're not here? I don't know. Are they being shielded from having to come to court and testify about these weapons? I do find that there is sufficient evidence for me to issue a 12-month protective order. It is a shame as to the ramifications of these orders, but there are consequences. And I will flat out tell you, I will enforce my orders. So both of you, there will be, the majority of it pertains to the respondent, but there are issues that will pertain to the petitioner as well, because you do have a minor child, and there will be issues that will arise, and I expect both parties to comply with each and every provision of my order. All communication regarding the child will continue by the Family Wizard app. That's the best documentation that we can have if something were to go awry down the road where you can bring it in here. There will be no communication via telephone, via FaceTime, via internet, email, none whatsoever from the respondent to the petitioner. While the petitioner is not under a specific order restraining her from doing so, I would hope that she will get good legal advice as to the issues that may arise if she were to turn around and begin communicating. She is seeking an order that will be enforced, but that enforcement will be undermined if you violate that on your own. It's not something for which you'd be in contempt, but it would certainly impact how the court might rule down the road. As to the 2 Glocks, I want them turned over immediately. And I mean, today is Wednesday. I mean, by 5 p.m., Georgia State is not going to hold your weapons, period, or your father's weapons. The DeKalb County Sheriff is going to hold them. And they must be taken to the DeKalb County Sheriff's office at Memorial Drive by 5 o'clock tomorrow. When weapons suddenly disappear prior to these hearings, it strains the credibility or the believability for this court that they're now safe. If you went to your parents and asked for those weapons back, I don't have any doubt they'd give them back to you. The weapons that were in the picture in Exhibit G or H?
E, Your Honor. Petitioner's E.
D is in David?
I believe it was E.
E. Those weapons also will be held by the DeKalb County Sheriff. You need to include them with your 2 Glocks. You had them for several years, and for them to suddenly disappear with the pendency of this order, I want them turned over. they can, if you successfully go through this program, through this 12 months without issue, you can petition the court, and when it expires, you can petition the court for the return of those weapons. But federal law does prohibit you from possessing those weapons. And I'm not concerned about Second Amendment. I'm sorry that it has ramifications as to your employment. I don't believe it has sufficient ramifications in terms of you can deal with emergency management and you can deal with IT issues with your employer. But it is what it is. And I do believe that there have been sufficient threats, sufficient intimidation, sufficient volume of unwanted and harassing communication for me to issue this order. I have no question about that whatsoever. I know the respondent does, Ms. Robinson. I know you've argued zealously for your client, but I do believe that there is ample evidence for that order to be entered. Initially, as to the visitation, it will be supervised by Nia's Place in Decatur. Initially, upon completion of the 6 months of family violence intervention program, and you're going to talk to Mr. Ellis here in just a minute, or he may have, I don't know if he was on for a good period of time.
Yes, Judge, he had to step away. He said as long
Okay.
as we could get, they can put in the chat his email address and phone number.
Okay, if
In
you
the
will
chat.
do that,
Thank you, ma'am.
please send it to Ms. Robinson and to the respondent. But you need to call him by tomorrow, and he will get you set up in that program. Once that is done, if there have been no violations of my order, then your visitation, all of which is set forth in the consent order that y'all entered, the parenting guidelines, all of which will be restored at that moment. All I need to know is that you have finished the family violence intervention program. Once that is done, then a motion is filed and comes to my attention and there have been no issues, then I will immediately restore that. The two of you have got more issues that you're going to have to deal with. Just 3 months ago, you consented to things, and now nothing's working. I know there's a lot of pressure on people when litigation. I don't know if you had a trial date, you went to mediation. I think I heard that, and that's pretty much the last step before you actually get to court and try your case. And I know that decisions are sometimes made under pressure. If you feel there's something that's not working there, you can move to modify it. If you feel the other party has been in contempt, y'all can just litigate till the cows come home, as they say, and pay attorneys lots of money. No offense, Ms. Shockley and Ms. Robinson, but it's expensive when two people can't work it out. I gave the opportunity for y'all to do that before hearing the case today. I don't know what all the stumbling blocks were as to the insistence to go forward. I don't know who or whether both of you. No, let's go forward. But you had the opportunity, and I'm glad that your attorneys worked very hard with you to try and get that resolved. They're both good, experienced attorneys, and they knew that once you got in here in front of me, you're letting a third party decide things have decided on your own. But it didn't work that way. So for now, you're going to have to live with this order. And I will issue the order that will be sent out. Nothing else in your divorce changes. I'm going to deny both sides, obviously, the attorney fee issue. That's going to have to be, you got a lot more to go. But I'm not going to grant attorney's fees to either side in this case. Is there anything either party knows of or has questions about before I let you go? I'm sorry, either counsel, not the parties. I'm not speaking with anybody but counsel at this moment as far as anything that I've left out.
Not for me, Your Honor. Thank you.
No, Your Honor, and I have communicated with the clerk to provide Mr. Hawkins information.
Okay. All right. All right. Good luck to both of you. I hope that both of you will do what's right for Harrison. If I tell you what, I'm gonna change something here that I've already said I was gonna do. I'm gonna change it part way. I'm gonna change it to 3 months of involvement with the Family Violence Intervention Program. And then I will change it to where the exchange of visitation takes place at Nia's place. Until then, it'll be supervised visitation. After that, after completing and verification through Mr. Ellis that you have been attending the program as required, once you've done 3 months of that, then I will go ahead and reduce it to the 3 months. You can restore all the regular visitation with the exception of the exchange at Nia's place. Now, let me tell you, with Nia's place, they call it orientation, but basically you have to contact them, and the quicker you contact them and do minimal paperwork with them, the quicker all of this is going to get started. If you drag your feet, and I'm going to speak to the petitioner who has sole custody, I want you to get this done ASAP. Okay? As soon as possible, you contact Nia's place in Decatur. Ms. Goodman or Ms. Broom or Ms. George, can you give them the number via a chat? Anyone there?
Yeah.
Okay.
I could send it in a chat.
Okay. Because the quicker, I'm sorry, the quicker you do this, the quicker contact can be reestablished. Now, let me ask, in the divorce decree, was FaceTime a part of that consent?
I believe it was, Your Honor. I'm speaking just out of pure memory. I believe it was.
Okay, that too is suspended until the 3 months. Okay, after that, then everything that's in your original consent can be restored. If you modify it between now and then, that's fine. We'll go with whatever that may be. But until then, there needs to be a buffer here. And this is a Band-Aid until you can get things resolved in terms of any modification that you wish to file in your divorce, or contempts or whatever. Ms. Shockley, you have something?
I did have a question, actually. Certainly, I understand that Nia's place is good because it provides the supervision. It is somewhat of a distance.
So they're going to continue to talk about some scheduling, and we can keep watching it if you guys want. I just recall them going over it. I think what the judge did here was throw him a bone at the end. I don't think that the mom is blameless at all. I don't think she handled it appropriately necessarily, but maybe she did it the only way that she knew how, which was for her via money, it seems. I think he made his bed because he is a law enforcement officer and he's well aware of the rules and he should have followed them. There's no gray area when it comes to turning in pew-pews when you've had a TPO. Like, no, that's not, it just doesn't work. And then the same thing goes for just like he should know all of those. So he really needed to be on the up and up here. And if he had been, his case would have been totally different. If he had turned all those things in and shown up and been like, man, I'm, having a hard time with this, but a lot of his messages and a lot of his stuff was like, and as every lawyer will always tell you, and I'm not close to a lawyer, but I watch a lot of law on TV, on YouTube. You do what the court says and then you fight later. You don't defy a court order. And that goes for both of them. Um, they need co-parenting classes. They need a go-between for them. They need a very strict schedule put in place that will eliminate any discussion over who gets who on what days or holidays. Like, ideally, as co-parents, you can talk about those things as they occur or come up. But unfortunately, with a situation like this, that's not very feasible. So instead, the court needs to implement something very serious and stringent so that if otherwise they will literally just continue to come back to the court over and over again for minor infractions because they both have money, they both have hurt egos, and they both are immature. No offense. Maybe they're professionally successful, both of them seem to be, but absolutely immature in their communication and their abilities to deal with each other. And I don't know any part of what happened to make that way, but I do know that they all need to be careful, follow the court orders. He needs to get behind that bone that the judge just threw at him and take it and run with it. He needs to phone Nia's place today. And if that woman doesn't follow up properly, he's got the great case. But the judge gave him a very clear pathway. He gave him every single step that he needs to do and a time frame and how he can do it. And he basically put him in a 3-month timeout. And he's like, if you're going to sit over there for 3 months and you're not going to fuck around, and if you go ahead and you flout my rules, and the judge said it very, very obviously. He literally was like, listen, buddy, my rules, my court, very serious. So I think he got the message. That's when he got real about it. He was like, oh, this is serious. Anyways, I am so thankful that you guys are all here. I have reached 1,000 subscribers now. The time is like 7 o'clock my time, and what an evening I've had. This is a video, like, I sort of cheated. I didn't cheat. I can do whatever I want with my channel because it's my channel. But this is a video that I had already posted on my channel way long ago. I didn't get that many views. But the thing is, I think a lot of these things do better when we watch them together because I can't catch everything, but all together we can really crowdsource a lot of the things that we can learn from this and do the most good from them. I really enjoy finding courts, finding different places, finding um, different aspects of court. Also, you'll notice I don't edit out a lot of the minutia and the back and forth because personally, I really like to see that because sometimes it's very important and I'm not going to decide really what's in and out. My videos will just be pretty long and that's just the way it is. One day we're going to get really good with like a replay crew timestamp system. I have many, many plans and many thoughts, but don't worry that you're late if you're late because we have some breaking news. And yes, Pacific time zone represent. I'm on the west coast of Canada. Thank you very much. I am possibly going to cry laughing again because I would like to make a public service announcement here, but I'm going to do it in the form of a news video, guys. So first things first, let's get rid of these people. Go away. Up here we go. This is going to be good. You can probably hear the TV in the background. If that gets me fucking copyright striked, I'll be so mad. And you can hear him snoring. Okay, here we go. Ladies and gentlemen, thank you so much for tuning in to Kitchen Court Cases. This evening, however, I am bringing you an expose, an outing of sorts. It's come to my attention that there is a stranger in our midst, if you will. Somebody's been parading themselves through many of the chats that you might be part of, pretending to be somebody that they're not. Who could it be? I'm dying laughing. I can't even do it. Streamlabs. Did you guys know? Streamlabs. You've probably noticed Streamlabs in many of the chats that you go to, and I anticipate that you've seen so many mixed messages from the fellow, but also like, damn, this guy's in most of the things that I visit. So, I'm here to break the news that Streamlabs is not a person. That's a bot. It comes with the program that you use. Oh my god. I'm dying. Last night, somebody realized that Streamlabs, they thought it was real. And many people now, like, if you're not involved in the producing of something, the program that we use to stream is called Streamlabs. So people didn't think it was a bot. People thought it was real. Nightbot, too. Anyways, guys, I only have one quote, Jonathan. Seriously, I know. I bet people have been having conversations with Streamlabs all over the place. Like, man, this guy is like in every chat. But like, seriously, last night, Too Deep came to the chat and was like, I have some tea to spill about somebody who's modding. And I was like, what? Really? And then he explained, or she, I don't know. I don't know any of your genders. It doesn't matter to me, really. But in my brain, I have like assigned gender, whatever. I'm not even going to talk about that. Anyways, Too Deep came in, was confused, was trying to a little bit rat out Streamlabs because they had been putting out some pirate links in another chat that they were in earlier. And I was like, okay. And then I realized like they thought it was the same person, like an actual person. And then they thought it was like a mob mafia boss for YouTube. I was, it sent me for a spin. I was laughing so hard. I have to give out the dirt. It was so funny. Plus, you guys are still in the OG club. You're my people. So, Mayor, you can try and convince people that you're a human, but everyone knows you're the bot. How'd you get blue in all the rooms? The only real people you know are the ones that also talk on the screen. I'm just kidding, guys. Anyways, listen. You guys are my people. I love you very much. I don't know. I gotta wait till YouTube gets in touch with me. I've already submitted whatever. I'm waiting, but hopefully soon. I am gonna work on some things this weekend and get things going with, I think, a Patreon so that we can do some members only adult content. Not naughty, but naughty. You know. Daylight, thank you for telling. Also, actually, I used to think we should start our chats with ASL, just like they did back in the day when I was young. But anyways, I love you all very, very much. I really, really, I'm just very thankful for all of you guys and your likes and your comments, your subscriptions, your ideas. I love hearing them. I want to talk to you guys. I want to get the chat up on the screen. I just got to get better. I'm learning. But things getting real now. So don't you worry. We're going to be doing fun things. I'm calling it, we're doing bingo next week. Okay? I'm talking about a real bingo game. I will have the cards. You got to bring your dabbers or whatever you're going to be playing with, okay? And I'm talking about in your mind because these are not real. You're going to get not yet. We'll get real ones. Anyways, I love you so, so much. I am going to get going because my dinner is almost here. I've ordered dinner tonight. I have a clean kitchen. I have 1,036 subscribers. Woo-hoo! I'm going to go find more court. I'm freak. I love it. I know you all do. I think you guys are seriously amazing. And I can't wait to have just oodles of fun with you for oodles until they're done, until YouTube's done. YouTube daddy can't get rid of me now. Anyways, guys, I hope you are great. And remember, you're valuable, you're awesome, you're worth something. I think you're really special. Okay? I mean it. But damn it, that's going to get me YouTube. He's going to get me all demonetized. I gotta go. I love you guys. Bye.